Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Oh man, that was a short lunch. That was a very, very short lunch. That was crazy. I helped build a wall on my lunch. Quickly scarfed down a roast beef sandwich with cheddar on homemade wheat bread. A little bit of Dijon mustard as well. It was delicious. No pickles, unfortunately. I'm out of pickles. I have plenty of pickled eggs, but no pickles. So we're going to have to make that do for lunch. Welcome back, Denise Feldman Ersland. Denise, I'm not sure if this is the first time. It may be the second, but I'm leaning towards the first. I think this is the first time you have won chat. Congratulations, Denise. It is wonderful to have you here. And you seem thrilled to win with a big ha. I'm not sure if it's a ha, would you look at that? Or more like a ha-ha. Either way, Denise, congratulations. You're the winner of the internet. Thanks for being first in chat. I think there's a peaceful transfer of power going on. It looks like Sharon McDonald is going to relinquish what control she had. She did a fabulous job this morning. Denise, I expect nothing less from you. I appreciate you very much. Irish Bella, welcome. Adam Nusky, congratulations to Denise as well. Let's see, KX Star, TW on a Globe. Christine Hathaway Cooley, Pampered Glamper, Not a Drama Llama, Norma MCAT, Hip Hop Flip Flop, Lost Souls Paranormal, O-Town Chill, Horse Sheet, and Bananas, Maryland Skull. Let's see, Golden Girl, is it Friday yet? Almost. We're still on Monday. We're almost done with Monday, though. I'll tell you what, I want to get done with Monday. Let's go ahead, if you guys will forgive me, let me skip the roll call. So we did a pretty good roll call this morning. I got most of you marked down. Linda Hill, I see you there. A couple people, Christy Busby. I want to make sure Heather Barnett as well. Anyone that's raised their hands, I just want to acknowledge. Dallas born, Boston bred. Great, good to have you here. Dilly Pickles. We've got a Spartacus battle going on between two Danny Austins, one in green and one not in green. So that's interesting. But not sure what's happening right there. Yep, it's a clone. There's a fake you. That's interesting. Red Pen, welcome, Minsky. Here we go. We're going to go ahead and kick this off right away with going back to court here. And
just set up a hearing on our calendar for this. It doesn't even have a case number yet.
Okay.
Hello. Would you come down, please?
Okay.
Thank you.
Would you come down? It's very informal.
It doesn't have a case
Judge
number.
Newman would be, bring the jury.
I have to have a little bit of a semi-hearing to determine if it's to be sealed or not.
Okay.
But, he didn't, well, it's taken care of.
Lots of people standing around in the courtroom. Hard to get a shot with these cameras. Let's see what's going on here. Okay. That's some really cheery lawyering right there. She seems quite happy to be there. Bring the jury. Susan Bond, welcome. Good to have you here. Carol Lux Lobos, all back, ready for more. We are going at 1.25 speed. This is the last. We've got less than 2 hours. Let me look at the time, actually. Let's see. We have. We're at 6:45 right now. We need to go to 8:13, and we're going to 1.25 speed. So who's our mathematician here who can figure this out? How long we're going to be here? Charlie comes in with a gifted membership yet again.
Have they already signed that paper?
The button is stuck. He keeps gifting memberships. Doesn't know how to stop. I'd rather be day working. Congratulations.
Photos of the burn pit excavation at the tree farm.
Correct.
You had also been aware of the work that they did on the burn pit at Mr. Anderson's home, correct?
Yes.
And similar to that, they did a grid of the burn pit and put the contents in buckets, correct?
Yes.
Show you what's been marked as Defendant's Exhibit 227. Can you explain to the jury what that is?
Those are the 5-gallon buckets that the contents from the fire pit were put into.
A lot of buckets.
And Defense Exhibit 228, just a different picture of those buckets, correct?
Yes.
I think they should have gamma
And then
lights.
Defense Exhibit 229, this is are individuals from agencies sifting through all of the contents of the burn pit, correct?
Correct.
Debbie,
And
thank
that
you so
too
much.
was a
Good to see you in
meticulous
green.
process
Thank you
of the
for your
burn pit,
support.
correct?
Yes.
Going back to Mr. Gutierrez's house, had you gone to that location, 3709 15th Street, during the evening hours?
On which day?
On any date? Had you ever been there in the evening when it was dark?
Yes.
Okay. I'm going to show you what's been marked as Defense Exhibit 57. That, above the lettering 3709 or numbering, is a light, correct?
Yes.
And that was on during the nighttime hours, correct?
I do not recall.
And then you also took photos of the dumpsters at the property around 3709 15th Street, correct?
I know photos were taken. I do not know if I know who took them.
All right. If I showed you, would that help refresh your memory?
It may.
This guy's like, I may have taken some pictures. Not sure if it was me.
I'm not positive because I know other officers prior to my arrival took photos of the dumpsters.
Okay.
Rainbow light, thank you so much. Appreciate your support. 2-month member,
So
looks
going
good in
back
green.
to The burn pit at Mr. Anderson's home, you previously testified that you had located or seen a sock, correct?
Yes.
But you didn't see any blood on that sock, correct?
Correct.
And you didn't swab that sock or process it for DNA evidence?
Correct.
You don't know if any other officers did?
Correct.
Then you had noted that you had seen multiple buttons that were recovered from the burn pit,
Yes.
and that you determined that they were from Levi Strauss pants.
Some of them were, yes.
And had you observed pants that Mr. Anderson had been wearing?
No.
But it's possible that those multiple buttons came from different pairs of pants, correct?
Correct.
Orange is
Talked about
12
the
months,
fact that
Debbie.
there were
12 months is
what
orange.
appeared to be tops from steel-toed boots.
Yes.
You'd agree that you're not a shoe expert, correct?
Correct.
That's just from you observing it what you believed it to be.
Correct.
But you also recovered from the scene a pair of work boots, correct?
Yes.
Break out the boots. ASMR time, big box. Another Amazon delivery incoming to the witness stand. Hope you brought a lot of gloves. Richard, I'm sorry.
Bang diggy 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 said.
I'm sorry about that,
Okay, I'm
Richard.
going to hand you what's been marked as Defense Exhibit 234. If you could open it, please. And before you open it, if you could tell the jury what your understanding of what the contents of that box are.
Thank you, Charlie, for the Kid Rock reference. Ba with the ba, the
These are Red Wing brown steel toe boots.
ba with the ba, the bang, diggy diggy. Yeah. Red Wings are good boots. It looks like he's showing his piece there on the side. He's printing quite badly there as well. Love Kid Rock. We have get quite a few references to his music in here. They turn off the mic for some reason. Not a big fan of ASMR in this courtroom. Unless it's the judge's phone. Yeah, buttons sounds offensive. She's like, buttons. I don't know. It's weird. Buttons. How do you spell that? No T's in buttons. Now he's got the gloves on. Pair number 2. Should be a pair of Red Wings. Nice work boots. High quality work boots.
That you recovered from Mr. Anderson's property, correct?
That's correct.
And you did not observe any blood on those boots, correct?
Correct.
Thank you. You can just place them back in the box.
They took all his shoes. Margaret, if you're listening, I've tried to process a refund. Apparently the mail lost your mug. Thanks for letting me know. We can get that fixed. I've tried to process the refund first. It might still arrive, but it's been delayed somehow. And I
So
can't find
other
it.
evidence that you had gathered were fluids that you had collected from the sink catches at Mr. Anderson's home, correct?
Yes.
And can you explain what a sink catch is to members of the jury?
Sure. So in the lower portion of your sink, if it's like in your bathroom, let's just say, usually there's a cabinet. Inside that cabinet, there's a little U, and that U holds contents when it goes down, the water. So what I did, I shut the water off, and I took the U off and emptied those contents into jars.
And what's the reason for doing that?
My supervisor had me do that just to see if there's any evidentiary value to
Find
any
jewelry.
biological fluids or anything inside it.
So when you say evidentiary value to the fluids, basically do you process that and collect it because if someone had washed something down the drain or was cleaning bloody hands,
Correct.
that it could be that some of those contents are found in the catch.
Right.
So you obtained the fluid from the sink catch in the kitchen sinks that were there at Mr. Anderson's residence.
Yes.
And that kitchen sink had 2 catches, correct?
Correct.
And you collected the fluid from both those catches?
Yes.
And to your knowledge, there was nothing of evidentiary value found in that catch, correct?
I collected it and put it in evidence.
Okay. And then you also collected the fluid from the sink catch in the downstairs bathroom.
Yes.
And then you said when you were doing this that you couldn't collect the fluid from the upstairs bathroom sink because it was not workable.
Correct.
And then at 3709, you also did the same process with catches in Mr. Gutierrez's apartment.
Yes.
And that was from the kitchen sink catch
Yes.
and the bathroom sink catch.
Yes.
His job was contractor, but he also had a marijuana grow farm, which might have been his primary source of income.
When you had gone to the tree farm on May 27th, 2020, you took overall photos of the scene there.
Yes.
And you did not find or see any human remains.
That's correct.
And you didn't find any bloody items.
Correct.
And you didn't find a body.
Correct.
And you didn't find what appeared to be a murder weapon.
Correct.
In memory of my good boy.
And then when you were at Mr. Anderson's residence, you also, when
Richard,
taking photos, did not
my heart goes out to you,
find
man.
or photograph any
that is
human
not
remains.
fun.
Correct.
No body.
Hopefully we got some great
And
pictures
no
and great memories.
what was determined to be a murder weapon.
I collected some items. I can't comment as to whether it was a murder weapon or not.
You collected a hammer, knife, things of that nature.
Correct.
But you didn't test those or anything.
Objection. He doesn't test any items. I think that's very
I
clear.
did not hear you, sir.
He doesn't test any items. I think he's testified to that multiple times.
Well, he has.
Those items you just collected because you were asked to collect them, but you don't know what happened afterwards.
That's correct.
But you didn't photograph any bloody evidence at that scene.
Correct.
And you had talked about a sheath. Do you remember being asked those questions about a sheath that you processed?
Yes.
And that one you did swab what appeared to be a red fluid substance on that sheath, correct?
Dried substance, correct?
Yeah. And then, but when you swabbed it, it didn't produce a red substance on the swab tip.
Correct.
Do you not have any further questions subject to recross?
Any redirect?
Yes, Your Honor. Thank you. Officer Van Wee, were asked some questions in cross-examination about your need for math, I think specifically trigonometry, and whether that was necessary for an individual like yourself to render opinions. If you have not taken trigonometry, do you have a method that you can easily utilize to make sure that the math is taken care of?
Yes.
What do you use?
Calculator.
Scientific calculator.
Okay, and so using a scientific calculator, have you ever had any issues in terms of doing the reconstruction or doing any of the sort of things that you were trained to do in your 40-hour course?
No.
Now, you were asked some questions about your crime scene experience with something called sharp force trauma. Do you recall those questions on cross?
Yes.
And sharp force trauma is essentially when someone is stabbed with an object. That's another way of saying that, correct?
Correct.
I'm going to object. This is all leading.
What, if anything, can you say about what you would expect to see at a scene if somebody experiences sharp force trauma? So, in other words, what are the crime scene signs that you would see if there's a sharp force trauma that is a part of an incident?
I'm going to object to relevance as to what you would generally see in other scenes.
Well, this was all examined on cross-examination.
Objections overruled.
Go ahead.
There's a lot of variables involved with stabbings. So it depends on how many times somebody was stabbed. You're going to see in the clothing that somebody's wearing. But generally, you're going to see a lot of drip stains because of the fact that blood's going to be dripping down from that bloody source.
And what, if anything, can you say about the crime scene that you testified to? Was there abundant drip stain evidence in this case?
There's a lot of drip stains between the dinette area and the living room where the blood saturation stain is.
Now, you were asked a question or answered a question by talking about arterial spurt. Do you recall bringing that concept up as part of what you were asked on cross?
Yes.
Okay. And you were asked, well, could you puncture an artery by using a blunt force object, or it breaks off in shards? Remember being asked those kind of questions?
Yes.
What would you expect to be the most common way a person would puncture an artery?
Objection, relevance, and speculation.
So, Judge, the question was asked whether these other things are possible. So he is an individual who's seen a number of crime scenes. Wouldn't it be relevant for him to tell us what is most common in his experience?
If we wanted to sit down with him and have him recount all of his police experiences, yeah, that'd probably be very educational. But we have limited time to get the case done.
Sure.
And I imagine these people can pretty well understand for themselves the various methods and plus some that people could use to inflict injuries upon themselves or others.
Thank you. Officer, you were asked a question about whether gloves would, whether a person wearing gloves where they receive blood on those gloves, whether you would expect to or would expect to find evidence of transfer. Do you recall being asked that question on cross?
Yes.
Okay. And you indicated in response as well that you were specifically not aware of any transfer evidence in this case. Do you recall saying that?
Correct. There's nothing obvious.
So I'm going to ask you to turn your attention to Exhibit 1, Photo 54 for just a minute.
I think I would rather puncture an artery than do trigonometry. I think that's why I connect the two. Let me just say the argument we dropped off and we cut off yesterday, that the judge was just talking and rambling. He talked about everything from breast implants to police officer hiring rates.
Identified as the doorknob on the interior door. So after you come out of the hallway, it's the doorknob you would use to close the door and be inside.
Yes.
And you indicated that there was blood on this in your direct testimony. Is that right?
That's correct.
And when you were asked the question, was there any evidence to you of transfer stains? Were you remembering this exhibit, Exhibit 54?
That's a possibility that that's a transfer stain. I just don't think there's enough conclusively to say that that is indeed a transfer stain.
Okay.
But there's a possibility.
Is it consistent with a transfer stain?
It's really too small to tell, but there is some consistency to it, yes.
So can you, with the pointer, just point out what area of this doorknob, and again, this would be the door that would close the door from the hallway.
Objection asked and answered.
What's
about what doorknob this is.
Just go ahead.
Okay.
Answer the question, please.
So can you point out with the pointer where on this interior doorknob you're saying there's evidence that at least would be consistent with transfer? Okay, thank you. You were asked to identify some smearing patterns, possible smearing patterns on the floor near where the blood had pooled. Do you recall that?
Yes.
So I'm going to ask you if you could bring up Exhibit 139 or Picture 139. You recall being asked about this?
I'm going to object. This is all extremely cumulative.
I'm countering things that were said on
means
cross.
Go ahead. Just
it's all adding up to look really bad for my client.
I can go ahead. Do you recall being asked about this pattern?
Yes, I do.
Okay. And you were asked whether this could be a sign of a struggle. Is that correct?
Correct.
Okay. And so this could be an individual who is bleeding with clothes on, and they are in some way struggling at that location.
Objection, leading, and speculative.
Your Honor, the counsel asked whether it could be a struggle.
And I was cross-examining where I can ask leading questions.
Understood. And I'm just directing.
Well, and directing to the finish line.
With leading.
I want to turn your attention to picture 218 for just a moment.
Are we going to address subject matter jurisdiction?
So there's a number of bloodstains on here, correct?
Correct.
Is there anything about the bloodstains that we can see in this that are inconsistent with a person being stabbed as part of what happened on that couch?
I'm going to object. Calls for speculation as to what occurred.
I don't think it does, actually. Objections overruled.
Is there anything about this that says that part of what happened could not be that a person was stabbed?
No.
You were shown a picture of a bleach bottle and also shown a bleach bottle where you lifted it up and told us how much was in there, right?
Correct.
Did that bleach bottle that you looked at here in the courtroom still have its label on it?
Yes, it did.
So is that the same bleach bottle, if you know, as the bleach bottle that you found the label for in the fire pit?
It was not.
It's a separate bleach bottle?
Correct.
Grinning
Okay.
face with big eyes, smiling face with smiling eyes and rosy cheeks, straight mouth, face with one raised eyebrow, face with hand over mouth, rosy cheeks, and
You
smiling
indicated
eyes,
as to
smiling face
exhibit
with sunglasses,
226.
grinning
You
cat
recall
face,
there was a
grinning
number of
face
pieces
with
of paperwork that
squinting
were
eyes,
in an
grinning
exhibit
face
that you
with big
saw?
eyes rolled up
Yes.
newspaper.
Now, I couldn't quite tell from your testimony, so just please clarify.
Thanks, Matthew.
Are you
Appreciate
certain that you are the person who collected that paperwork, or do you not know for sure?
So I didn't take anything out of the van. It was handed to me. So I didn't.
So
I photographed it.
So I'm just going to ask you, if my records indicate that Officer Giovannini collected those materials,
Okay.
what, if anything, can you tell me about whether you were involved in the collection of those materials?
Then I was not.
Okay. And so you were asked a question on cross about whether those materials came from the van, were you not?
Correct.
Okay. If I add that piece of information,
I'm going to object to this line of questioning. It's completely speculative. The witness has already answered then that he did not receive those items. So what happened or where those items came from, he can't testify to. It would be hearsay. The other officer can testify to that.
Judge, he was specifically asked the question, did you take this stuff out of the van? I think the jury is left with the misimpression that this material is from the van. I think I have an ability to clarify because only one officer took materials from the van. It's this officer.
The objection's overruled.
Okay. So, officer, now that you know that Officer Giovannini may be the person who took that paperwork, do you know for a fact whether that paperwork is from the van or not?
I did not.
Now, you were shown in cross-examination a number of buckets that were in a van or a truck, right?
Correct.
Okay. And you believe those are from the burn pit that occurred at the Mequon residence?
That I don't know.
Oh, you don't know where those buckets are from? Okay.
From those pictures,
Yeah.
which I do not believe I took, I don't know which fire pit those came from, if it was Mequon or if it was Random Lake.
Okay. In any case, you've testified to a number of items you took from the burn pit. Do you recall that?
Yes.
I'm talking about Mequon.
Sorry.
Some buttons, underwear, and sock, right?
Correct.
Okay. If you can you tell us, were those taken from the top area of the burn pit, or were they the kind of items that were only recovered in buckets at later layers?
They were recovered before we did the bucket system.
Okay. And so where would they be in terms of top to bottom of that burn pit?
The top, because they were visible to our eyes when we were looking at the fire pit.
One of the things that one of the things that you were asked about was whether you had found components of steel-toed boots, in other words, the steel toes, and you were shown a set of boots, correct?
Correct.
Do you recall being shown this picture and being asked to identify whether you had found? I apologize. If you take a look at 280, does this picture depict those steel toes, or at least a depiction of the steel toes that you discovered in this case?
Yes.
Okay. I'm going to ask you to take a look at States 118. Do you have gloves up there still?
No.
He's gone through a whole box of gloves. Some witnesses just get lucky and get to open all the boxes, and this happens to be the guy.
You could open 118 for me, take a look inside, and my first question for you is if you can tell me, are those the steel toes or the components that we're talking about that you yourself saw in the fire pit and the Mequon address on the 20th of May, 2020?
Thanks, Matthew. Have a great day in court. Hope you win it all. I don't think they're trying to say that any body was burned in the pit. I think some clothing might have been disposed of there. This witness with the wisp of hair, I think he's trying to pull off a mohawk.
This is the steel toe that was unearthed in the fire pit.
Do those appear to be in the same condition as you saw them back on May 20th, 2020?
Yes.
Okay. Is there one or two of them in the bag?
One.
Okay. All right. And thank you. Can you indicate, do those appear to be the actual ones that you saw at the time?
There are two.
To the use of a plural term, there's only one.
Did I say they?
Yes.
Does that steel toe appear to be one of the ones you found at that time?
Yes.
Is the other one that you found similar in appearance from your recollection?
Yes, it is.
Okay.
Where is it?
So Judge,
They
I
were
move
both
admission
there.
of this exhibit based on his testimony.
Is there objection?
No.
See?
I think they saw.
Said I think they stuck together. Yeah, they were stuck together.
Judge, I want the jury to get a chance to see it. The officer held it up. Can you just inquire of the jury, did they get a chance to see it, or would they like him to hold that up better?
Anyone? Why don't you hold it up, officer?
Watch them fall apart. Then you'll have two.
I'm sorry, are there two?
One and two.
I think they're together.
He's trying so hard to get the guy to
Okay.
pull them apart.
All right.
Yeah, the way they work, your foot goes underneath and it
Now,
arches over the toes.
there was also a set of work
There's
boots
nothing
found, as you testified to, correct?
Yes.
You don't have any knowledge of whether there was a second set of work boots, whether someone borrowed a set of work boots. You have no knowledge of any other facts about why there would be a second set of boots that might be of interest to people.
Correct.
Now, officer, you have offered opinions on cross about blunt force trauma being the source of many stains in this case. Are you indicating, what if anything can you say about whether you're indicating that all of these areas of blood or bleeding were all administered by blunt force trauma as opposed to other weapons also being used as part of an attack?
I'm not going to rule out other weapons being used.
No further questions, Your Honor.
Any question?
Yes, thank you. As far as the items that were recovered in the burn pit at Mr. Anderson's home, you have absolutely no way of telling when and where, or when those items were placed in the fire, correct?
Correct.
You have no way of telling who placed those items in the fire.
Correct.
And to Attorney Gradley's questions about you can't rule out what weapons were used or what weren't used, you also cannot determine what weapon was used, correct?
Correct.
No further questions.
Nothing on those.
Thank you. Please step down.
Okay, done with this witness. I think we've got one more here to wrap up yesterday, and then we'll begin with this morning's.
That's red. Is the
We have blood to reseal them, so just bring them.
is Sister Marcian's pointer up there too? Yes, it is. I don't want that to fall into the wrong hands.
That has magical powers in it. I'd like to see the judge wave it. Oh, there it goes. Abracadabra. And poof, the witness disappears. Why is she so angry? She needs a Snickers. That's mostly it. She has a very direct style in how she lawyers. Why is he sitting during questioning? Great question, Medusa's child. In this courtroom, the They sit for the most part while questioning, although sometimes they do stand. It's not a requirement for them to stand. There are some states, like in Texas, where they do require them to be seated. We saw that in the Juan David Ortiz trial.
Is there an objection?
No objection.
Received.
Sorry, 233, 234.
Wait until we seal, or should we bring another witness up and let the officer seal it next week?
That sounds like a good idea.
7.
Yes.
Okay.
The state would call Celia Patterson to the stand.
Celia Patterson. 7. Obviously, you have not opened a fresh jar of spicy maple bourbon pickles. I would say I might have you in spades there.
You solemnly swear the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth. So help you God. Please be seated.
Okay, she has a ribbon on. That means she's probably family of the victim. Maybe the mom. Is this the mom?
Could you please state your name for the record and spell it?
Celia Teresa Patterson, Selia Teresa Patterson.
Mrs. Patterson, do you know someone by the name of Rosalio Gutierrez Jr.?
I do.
And who was Mr. Gutierrez Jr. to you?
He was my only child.
And
this is
when was Mr. Gutierrez born?
April 10th, 1980, here in Kenosha.
And growing up after the age of 2, were you a single parent?
I was. I was a single parent from the age of, my son was 2 years old when his dad and I split up.
Being a single parent, did that make you and your son very close?
If I may refer to my son as Pocho. Pocho and I were very close. When he was born.
I'm going to object. I don't know how this is relevant.
Judge, if I may.
I'm going to ask the jury to step out for a second. This should just take a minute.
Okay, while the jury's stepping out, let me answer Nem's girl's question. The first mistrial happened because there was a witness who changed her story. The prosecution re-interviewed her, namely the Steve Martin attorney re-interviewed her himself, and then did not inform the defense about her change of story. And so that caused the mistrial. And that keep that in mind, because that's gonna come up here pretty quick.
Pocho.
Pocho?
Let me just clarify. You're wearing a ribbon.
I am, sir.
What is it?
It was for my son's celebration of life.
Yeah, and
Okay, I'll remove it.
Being
no, that's, I don't
a
understand.
very strict rule about that, so.
No problem, sir.
No, you can leave it on for the rest of the day, but in the future.
No, I'll remove it. That's okay.
God bless you. Now,
Okay, ribbon comes off.
What was your response?
So, Judge, this goes to whether or not Mr. Gutierrez is actually dead. The relation. So it's completely relevant.
I think it's appropriate that she gives some historic and biographical information leading up to a very relevant point. The state is required to prove is that the named person is indeed deceased.
Two things. One is the way that they're doing it appears a ploy to garner sympathy. Number one. Number two is that I understand the court's view that that's a relevant point, and they do have to prove that there was a death, but they're proving it through utter speculation. I mean, it really is.
Well, I haven't heard those questions yet. They could be, or they could not. They might not be. So we'll await that. It certainly is something that they could do without any speculation, testimonial speculation, and leave it to the jurors' inferences, which they're allowed to draw.
This is the victim's mom. Victim's mom.
I don't think there's any problem with what's come out so far, and I assume that it will be limited in duration. So,
and
as far as trying to get something from the jury, look, if the incident occurs as the district attorney claims, they don't need to do anything more to get sympathy from people. especially the mother.
Fair point, but I was just referring to, if you remember the testimony earlier from one of Mr. Gutierrez's, the mother of his son, testifying at length about, how much they played baseball, and how close they were, and all the phone calls with the son, and all of that.
That was the end of yesterday.
It was just unnecessary. And that's what I hear coming now with Ms. Patterson. That sort of thing.
I have to say, I think we did have some discussion about the baseball, but again, the district attorney was relying on that to prove the death, and again, relying on inference, and 10, and let's go ahead. The objections are ruled.
Big Sky DMC, thank you for joining the gallery. Appreciate your support becoming a member. Please type !seat in chat and take your seat on the front row. The view's fantastic.
Hold 1 second. Hold 1 second.
Hold the jury.
Hold 1 second.
Hold 1 second.
Hold the jury. Audio was rough.
Notice now that there are 2 others at least that are wearing badges or pins, ribbons. And perhaps Ms. Busy can speak with them. We'll leave it for today, but in the future, no. Thank you. Yeah.
So maybe the other people wearing ribbons may have to take theirs off right there. Boom. I know that seems heartless, but that is common in the courtroom. There are some judges that won't allow any buttons, stickers. Think of the Parkland shooter case. The buttons, anything that commemorates or celebrates life or might garner sympathy or make the jury feel one way or the other. They pretty much have to come in there in just pretty much very blank, nondescript clothing. So it's harsh to see a mom testifying about her son, who is believed to be dead at this point, have to take off.
Thank you. And the objection has been overruled. Go ahead.
It should have been handled before then, instead of in front of the jury.
Being a single mother, did that make you and your son incredibly close?
Yes, we were extremely close, my Pocho and I. He was my life. We did everything together. My life evolved around my son. His deeds, I did my best by him, and we were extremely close.
Go ahead.
What did your son like to do with his time? What was most important to him?
Growing up...
I'm sorry, I'm going to object again. This is absolutely not relevant.
Ordinarily, this type of evidence
talking to the jury here
is excluded. Evidence which is likely to create special sympathy, and of course, in the eyes of the court here, the closeness of a mother to a child, or any other relationship, it's not something we consider. Every life is viewed exactly the same in the court, so that we don't have a hierarchy of the value of human life. So this type of evidence is not ordinarily permitted. I'm permitting it in this case to give you enough acquaintanceship, because there was already reference to it in the case earlier as to what the reaction was of the friends and family of Mr. Gutierrez, and so that you can draw your own inferences as they arise from the testimony as to what that means if people who were close to him did not have contact with him, even for 2 or 3 days.
Big Sky, that's a setting I have. I can turn it off.
What the defense is concerned about is that you not become so sympathetic to this lady that that will affect your verdict. Any questions about that? Okay, thank you. Go ahead. Objections overruled.
Mrs. Patterson, what in May of 2020 was most important to Pocho?
His children, his communication. So, we had lengthy conversations, so we kept a very close contact with one another. Text, phone calls, video chats. He would always keep in communication with me. He would always respond to my phone calls. And if he couldn't, He'd say, "Can't talk now, Mom. I'll call later." He would text me.
Would you consider your son to be kind of a mama's boy?
My boy was definitely a mama's boy, and he made no qualms about it. He was very quick to say so himself when he was teased during high school, that you're just mama's boy. And he would say so. He made there was no shame in it. His display of his affection for me, his mom, he would give me a hug no matter where he was or who was in front. He would kiss me. We were very, very, very close.
Now, in May of 2020,
no one's been kicked out yet.
were you
That'll
living at
happen
that
here in a
point?
little bit.
In Elbert, Colorado.
And obviously your son lived in Kenosha?
Yes.
And did you maintain this close relationship even though you were quite a distance apart?
Yes, we did, but I traveled back to Kenosha often.
And as part of your son being a mama's boy, did you help him out with financial things?
I did.
And would that include actually traveling back in January of 2020 to bring him a vehicle?
Well, actually, he came in December the 18th. He flew into Colorado Springs, flew into Denver for my commencement on the 20th of December. He was going to make that celebration with me, my accomplishment. He was going to share that with us. And then in January, I traveled here to Colorado, and in February as well.
We have 36 minutes to finish up today, and then we'll start on
February of 2020, would that be the last time you saw your son in person?
That would be the last time I saw him. The purpose for that trip was to bring him that Ford truck that he had.
The audience sort of grows and then fades away in the afternoons. The judge is allowing this in when he says it's normally not. I'm not sure if this I'm not sure if this is appropriate or not. It's normally not allowed for a reason. It's that special sympathy with the jury that might sway them.
What's been marked as State's Exhibit 54. Can you tell me what this top picture is?
Yes, that photograph was taken in Milwaukee, right outside La Quinta motel. He had dropped me off there because I was flying back to Denver on the following day. That's my son, Bocho, with a truck that myself and his dad bought for him so that he could go back and forth to work.
And approximately when was that picture taken?
That photograph was taken on, I believe, on the 3rd of February or the 2nd. It was on a Saturday because I flew back on a Sunday, I believe.
And then these two photos on the bottom here, what are those?
That's me and my boy. We were at Pikes Peak he flew in to Denver for my commencement on the 18th. That photograph was taken on the 19th because I graduated on that Friday, the 20th. So we were at Pikes Peak. We were just hanging out. We had gone out for breakfast and enjoying the sights, killing time, enjoying each other's company.
I love that she went back to school.
Obviously, you're very familiar with your son.
That is awesome.
If you had to estimate, knowing him, having seen him as recently as February of 2020, what would you estimate his height and weight to be?
My boy had dropped a considerable amount of weight from when he first returned from Colorado. So I would put him at about 240, 245.
And approximately how tall would you say he is?
I say that he was 6'2", though his dad says he's 6'1".
Now, you just referenced his father. You obviously were a single parent for a long time. Did that change at some point?
It did. His dad came into our lives when he was 10 years old, and we would marry when my son was about 16 or 17 years old. I was a single parent all that time. It was just me and him.
And when you married, what is your husband's name?
Eugene Warren Patterson, Jr.
And when you married Mr. Patterson, did he also grow incredibly close to your son?
Yes, he did.
I didn't hear the last thing you said.
I'd like to object now, and I'd like to be heard at sidebar. Or outside the presence of the jury.
Will the other person be testifying?
Will Mr. Patterson be testifying?
Yes.
No.
What is the inquiry premised upon here?
I guess I don't understand your question.
Where are you headed?
Just shoring up that he was also close to his stepfather and then moving on.
What's the relevance of that?
This is the situation. I mean, we have cases coming through here all the time. Sometimes there are people who are community figures whose lives are lost. Sometimes there are police officers. Sometimes there are people who have no friends and have got long criminal records, but they have something in common, and that is that the state is alleging that someone took their lives from them. And whether they're popular or have friends or money is totally irrelevant. Now, I've indicated to the jury what I believe the state is attempting to do here, which is permissible, but I don't think we need to go further down this avenue. Whether he was close to his stepfather or not, or his father or anybody else, is really not relevant, except as in terms of where we are now in this case, except as it bears on the fact of whether there was a homicide or not.
Right, so
the objection is sustained.
But just so I can be heard, part of the thing, I don't know if you've been told, obviously this is a bodiless homicide case, so we have to prove that he's actually gone. And so in laying the foundation for that, as well as all of the help, as well as all of those things, and then no one's heard from him, is incredibly important.
I think that everyone knows that. That's been talked about from the beginning by the district attorney. I'd be very surprised if the jurors aren't all fully aware of it. And I just mentioned it to them in the last 10 minutes, why we're permitting it. So I don't think that further explanation on this issue is necessary.
I'll move on. Mrs. Patterson, you had indicated that you helped out your son financially. How did you go about doing that?
My son and I had a shared bank account with Chase, and
I'm going to object on relevance grounds here too. What on earth does the finances have to do with whether or not
They could.
We had a shared bank account with Chase, and I knew when my son was struggling with his bills, we helped him with his rent. We actually paid for his lease for his apartment when he rented in May of 2018. My boy was an extremely hardworking man.
Go ahead with your next.
Judge, I didn't hear you.
Go ahead with your next question.
You indicated about helping with the rent when he first rented his place. Would that be the same apartment on 15th Street?
It is.
And were you actually with him when he picked out the different furnishings for that apartment?
We were together, yes.
So, Judge, this goes to what was in the apartment and what...
Give us a moment, will you?
This audio is awful. Whoever's running the audio microphones in the courtroom, they're turning up a microphone that is away from everyone who's speaking. And so they're getting all the air conditioner noise in the background, and then you can barely hear the people. And then so they're turning up the wrong mic. It's like a room audio instead of the witness's mic. They need Doug. Charlie, thank you so much for gifting yet another membership, and this one went to Ed Gein. Congratulations.
Whether he had old furniture he had for many years.
Sorry, that was on a globe. I apologize.
Or whether you went
Charlie,
to John M. Smith or whomever.
I gave you credit for Richard.
New furniture.
Richard, thank you very much.
Because she was with him when the furnishings were picked out, right. She's familiar with the area rug. She's familiar with what it looked like, what should have been there. So she's going to be able to offer essentially the layout of the apartment and what was different, or when she actually ends up doing her own walkthrough after the scene is released, being able to offer first-hand account of what that rug should have been, where it should have been, all of the different things, because she had spent a considerable amount of time in that apartment.
To the extent that that is helpful to the jury, that doesn't involve her having been there when it was picked out. If you want to say I was familiar with where his belongings were in the residence and what changes she observed when she was there, you may do so briefly, but I don't think we need to go back to when these things were purchased and take this woman through these memories that must be bittersweet and really are not going to help the jury that much. Any question?
No.
Thank you. All right.
Judge, before we do that, there is an issue that I do want to raise. The exhibit that's up on the Elmo right now, the defense hadn't been provided that exhibit previous, nor were we provided any information about when Ms. Patterson last saw her son in person, nor have we been provided any information about this furniture. So from the questions that have been asked by the state and the exhibits that's been introduced, it's evidently clear that there's information that the state has as it relates to this witness that was not disclosed to the defense. Now, the picture, non-instrumental. I can run with the picture as it's presented. The facts that Ms. Patterson are talking about, it's not going to make or break the case. But what it does show is that the state has information that they're using to direct a witness and question the witness and did not provide that to the defense, which is problematic on multiple grounds.
What do you want me to do?
Well, I want them to be ordered to disclose everything as it relates to Ms. Patterson to the defense. And two, I will be seeking a curative instruction that the state had information that it used to question witnesses on and that it did not provide it to the defense prior to this hearing.
Judge, our discovery obligation is to provide written
I don't want to get into
or
an
recorded
extended
statements.
discovery. No, we're done talking about discovery for now. I want to get the jury back in here. It's 18 minutes to the hour, and I'm sure they would like to get home on. This is important testimony, and I'm sure it is very painful for this lady to get it and then get sidetracked with all these lawyer arguments. So let's just get back to work.
Hey, Michelle, I saw your message about the emojis and the gifted membership. I'm looking it up right now to see. There's a chance, is it possible that you're logged in on a different user ID? It should, YouTube's really good about these memberships, so it should work for you. There's a chance if you have another password, another email you use to log into YouTube, it might have been gifted to that one. Yeah. The judge jumped on the prosecution. Yeah, I'm curious. I wish we had some more legal representation here in chat with Matthew. I'm not sure if Nicole's available right now, but is that a problem? Maybe Mr. Upper Torso, somebody. Go
ahead, please, Ms. Kazari.
About this discovery. Is that an issue?
Were you familiar with the layout and the furnishings in your son's apartment?
I was.
And why?
Because I was with him when we furnished it.
In May of 2020, if you had to estimate, how often did you speak to your son at that point?
Quite often, at least 2-3 times a week.
And did you speak to your son via text messages on May 16th of 2020?
I did.
And were those the last conversations you had with him?
They were.
And I'm just going to show you State's Exhibit 55. Mrs. Patterson, is that one of the last text pictures that your son sent you on May 16th of 2020?
It is.
And after that conversation where that picture was sent to you, have you heard from your son ever again?
My boy hasn't reached out to me. My boy is gone. No, he has not communicated with me in any shape, text, email, phone call, FaceTime. I have not heard from my boy since I responded to this photograph.
How did you become aware that your son was missing?
I was called on the 19th of May, a little bit after 3:30, by Kayla Petty.
And just for the jury, who is Kayla Petty to you?
Kayla Petty is my granddaughter's mother.
And what did she share anything with you that caused you concern?
Objection calls for hearsay.
I'm not asking for the specifics, and it's also not for the truth of the matter asserted. It's for what she did next.
Well, you know, that, as I said, that's a way that is typically used by lawyers. Well, I don't want to say typically, but often used by lawyers to bring in the Trojan horse of hearsay. It's irrelevant. It's irrelevant what her next action was, and frankly, the whole fact of the phone call really is not instructive to the jury in terms of the fact finding that's involved. So, yeah, move on to something else, please.
After that phone call, what did you and your husband immediately do?
We traveled to Kenosha
And when did you arrive in Kenosha, if you recall?
on the 20th.
Now, we had talked a little bit earlier about a specific vehicle that you indicated you had driven to Kenosha for your son in January of 2020. Do you recall that?
Yes.
I'm showing you from State's Exhibit 1, photograph number 1. You can tell me what this is a photograph of.
That's the tail end of the Ford Explorer that I drove down for my son in February, that we purchased for him.
And does it have Colorado license plates?
Yes.
And was this vehicle registered in Colorado by you and your husband?
The vehicle is registered to myself and my husband.
And at some point during this investigation, do you recall being shown a document that had a handwritten address on it?
Yes.
I'm going to show you what is on State's Exhibit 1, and it's going to be item number 323. Do you recall being shown this item?
I do.
And on the right-hand side of this item, do you see the name Eugene W. Patterson, Jr.?
I do.
And who is that?
His dad, my husband.
And then do you see the handwritten address?
I do.
And is that your son's address?
It is.
Is that your son's handwriting?
It is not.
When this document was first shown to you...
Well, I'm sorry to interrupt, but when you're saying about the handwriting, there's two different, well, I don't want to say that. There may be two different types of handwriting on there.
Judge, valid point, I will clarify. When I'm talking about the specific handwriting I'm looking at here, it's the written out address. Is that your son's handwriting?
It is not.
Obviously, you've indicated Mr. Patterson is your husband. Is that his signature, though?
It is.
And when you were shown this document, did you immediately know what that handwritten address by somebody else was written on?
I did. I prepared it.
And what in general was the document that this was written on?
It was meant for my son to carry in the glove box for if he were to get stopped for some reason or another, it would be documentation that he was a valid operator of that vehicle with our permissions.
And is that because you have a different last name than him, so the registration would be under Gutierrez?
That is correct.
Objection was leading.
Oh, yeah, it was overruled.
Yeah, it was overruled.
Approaching with what's been marked as State's Exhibit 225.
It's too late. Need to object sooner.
Can you tell me what that is?
Yes, I prepared this document so that my son would have it in his glove box, authorizing him as the vehicle driver while he was here in Wisconsin. And both my husband and I signed the document. Not that one, of course.
And so, when you saw your husband's signature on the bottom, you knew this to be the document that you were looking at with the handwritten address by somebody else?
That is correct.
And when you gave this document to your son for the purpose you indicated, where was it to be placed, or where was it placed by him?
And his Ford.
Objection. How on earth would this witness know that? And if she does, then she knows it through hearsay.
Why don't you rephrase your question?
You indicated that you had driven this truck from Colorado here?
That is correct.
And did you bring this document with you?
That is correct.
And did you have it placed somewhere specific for the purpose that you stated?
I placed it myself in a glove box for my son.
That gets by that objection.
Any objection?
Object.
5-4.
Received.
I'm going to play with the audio and try to boost it a little bit, but she's running around the courtroom far away from the microphones and not talking very loud.
You came into town on May 20th, is that accurate?
Yes,
And eventually was the crime scene of your son's residence released?
it was.
And when was that, if you recall?
Yes, I do.
And what day do you recall it being, the scene being released to you?
The scene was released on May 27th, but I did not enter it until the 28th of May.
And when you entered the residence, that's a residence obviously you've been to before, is that accurate?
That is correct.
And did you do a general walkthrough of the residence when you entered it?
I did.
And what specifically were you looking for in your walkthrough?
Sorry. Are we caught up? Is this
when
victim's
you
mother
first
at
went back to
recovery
that
addict
residence?
red question mark?
Objection. I don't know how this is relevant either.
This is the victim's
She made
mother.
Some first-hand observations about
Thank you, Maisla, for the super chat.
I did an audio video walkthrough of my son's apartment, and I noticed that the sofa leg was broken. I also noticed that the area rug that he had in his apartment right in front of his sofa was no longer there. Not to mention all the blood that I saw everywhere.
Now,
She's
Mr. Patterson, you've been in the
leaning
courtroom,
right up into the
while
microphone.
Other people have testified. Where in the living room was that rug that you indicated was no longer there?
It was supposed to be in front of his sofa.
Was it placed in the space that's been referred to as the void?
That is correct.
It's bleeding, Judge.
Well, it is come leading, although, again, the objection of the lady is for questions induce an answer from a witness, and it would be my suspicion that that is less likely in this situation or in this evidentiary situation. So just as the last time, your objection is correct, but overruled.
Well, at least I'm correct.
Pardon me?
At least I'm correct.
At least I'm correct.
I'm going to show you a picture number 225. For the jury, could you point out where on this picture this rug would have been if it were appropriately placed? Judge, could she have the pointer?
We will have to stop and restart the
She's talking while
the
she's at
video
the board and
to do closed
doesn't have a
captions.
microphone, but she's outlined a rectangular area, generally a rectangular area. If you could.
Nobody can hear this but the jury.
Thank you.
She pointed out where the area rug should have been on the
mentioned
floor.
something about something being broken on the couch. What was broken on the couch that you noticed?
The leg of the sofa was broken.
Which leg of the sofa? Because it was kind of an L-shaped couch, if you know.
We're almost done with this day's audio.
Now, did it fall to you to clean out your son's apartment?
I'm sorry?
Did you take it upon yourself to clean out your son's apartment?
It was my job to do so. I didn't want anyone else to see what they had done to my son.
And was part of that cleaning out the kitchen area?
Yes, it was.
And was that one of the first tasks you tackled?
I decided to start in the kitchen, yes.
And why did you decide to start in the kitchen?
Well, because some days had gone by and I didn't want the apartment to start having an additional odor to it.
And ultimately, did you make your way to the refrigerator freezer area of the kitchen?
I did.
And what happened next when you were looking in those areas?
As I was removing some frozen items from the freezer, I reached to the back of the freezer and I noticed my son's cell phone, money clip, credit cards, driver's license.
And did you touch those items?
I did.
And at that point, did you have a glove on your hand?
I did not.
I'm going to show you what is on State's Exhibit 1, photograph number 298. If you could just tell the jury what they're looking at here.
The crime scene was released to her, and so she was cleaning it as it was appropriate. She wasn't not doing anything wrong. This is what happens.
That is my son's kitchen area.
The family has to clean up.
And is on the left side there the freezer refrigerator you're talking about?
That is correct.
Right, I'm showing you picture number 299. Can you tell us what this is?
Yes, that's my son's freezer.
And if you wouldn't mind taking that pointer again, could you approach the screen and point out where you found what you found?
I think she needs a microphone.
Yeah, do we have a microphone for her?
Hello? I had just removed my glove because I had punctured it and I did not replace it. But I reached into my son's freezer and I was taking these out of the way when I noticed something here. And I reached back over here towards the very back of the freezer, towards the wall, the back wall unit. And his cell phone was there, along with his money clip. Credit cards were up here, but his phone, money clip, was stuffed all the way towards the back of the freezer.
And looking at picture number 300, is that a close-up of something?
Yes, this is a better angle of where I found Pocho's phone. It was right here. It was laying flat, if I recall, and money clip was on top of it. There was also his driver's license and some other cards were up in this area.
And I'm showing you photograph number 301. Do you know what that is?
That's his debit card from Chase.
And is that the joint account you shared?
That is.
And then what are the rest of these items?
Here's his money clip, his Visa cards, and of course his Costco cards and his Home Depot and other belongings.
Now, were you familiar with, obviously, where your son banked?
I was.
And did it appear to you, knowing him, that any of those cards were missing?
No, I didn't think anything was missing. Everything, all his identifying cards and driver's license was all in the freezer.
You can grab a seat, Mrs. Patterson. You had previously testified that you and your son shared a bank account. Is that accurate?
That is correct.
And were you able to pull, since you also are on the bank account, financial records for that account?
I was.
I'm just going to show you what's previously been marked as State's Exhibit 37. Can you tell me what that document is?
It's a statement from Chase Bank.
And is that something you requested from Chase Bank yourself?
I did, yes.
And in looking at that document, after May 17th of 2020, with your knowledge of that account, did your son ever make an affirmative purchase from that account after May 17th of 2020?
His last purchase shows here was at Dick's on the 18th of May.
Is that when it posted, the 18th of May?
Yes.
And was the purchase actually on the 16th of May?
It says here that he made the purchase on the 16th, but it went through on the 18th, yes.
And ultimately, did you end up closing that account at some point?
Yes, I did.
And prior to closing that account, did your son ever make any purchases or withdrawals after May 17th of 2020?
He has not.
One of the attorneys is going to leave here in just a little bit. We're just finishing up the day. I think we've got like 7 minutes left on this video. I think we're going to end here. Let's see. Hopefully the audio from tomorrow's video, or it's actually today's video. So we're going to be starting the live video, but we're starting a little behind. We're starting at the beginning of the day.
May 17th of 2020, what kind of events has your son missed?
He has missed.
I'm going to object on the same grounds as we talked about earlier.
What kind of events has your son missed?
I'm going to sustain the objection.
Prior to May 17th of 2020, would your son have missed your birthday?
This is the same
No.
stuff.
I would have gotten at least a call.
So I'm going to object this. She just backdoored the exact same thing you just sustained.
She did.
Kind of sounds that way.
Yeah.
Well, but Judge, this
No,
was...
no, we're done.
I have no further questions.
Cross-examine.
I don't know if we want to start this, Judge. This is going to be lengthy. You want to rank for the night?
It's up to the court.
That part I know.
Seems like,
Well,
no, it's my decision.
There are a lot of considerations. The jury is one. This lady, I'm sure this is a difficult experience, and whether to break it into, I don't know. I think when you say lengthy,
It won't be that lengthy. I think the record we need to make about certain things as it pertains to this witness would be would take up more time, but we don't need to do that with the witness on the stand. I could anticipate this getting done in 20, 25 minutes, depending on...
we're going to break for the day.
Okay.
Okay, folks, please don't read, watch, or listen to any account of the trial. Don't discuss the case with anyone, even family members, other jurors. And any questions, anybody? Thank you, and have a great day.
Okay, so this is the end of yesterday. This was the end. This is how Monday ended. So now we're going to start with today, Tuesday morning. Just want to make sure nothing happens here the last couple minutes after the jury's out, because we do have just a couple extra minutes of video. I told you we're going to get caught up, and we're finally on today's video. So, oh wow, I'm just getting a teaser of what's coming up next. It's going to be good. Judge looks like a bald Alex. I can tell you don't like being caught up. No, I would love to get caught up. Oh my goodness. I would love to. It's so much easier on my front if we just watch live. The attorney gets booted early on, so we're going to see that here before we wrap for the day. We have not seen it yet. You have not missed anything. I think we're done. I think we're done. We're done. Okay, so let me go ahead and pull up the next video. We're going to bring it up.
Guys.
Just right here. Hold tight here, trying to get the feed right.
Bring the jury.
Bring the jury. So this is day 6, or sorry, this is day 5 we're watching right now. If I can get it to work right.
Are we going to address subject matter jurisdiction?
We should. Okay, so here's the start of today. So now we're on today's video, I believe. Nope, I screwed it up. I was making you watch the same one again. Here we go. We'll get here.
Was plugged into the witness one, so we were getting.
Right, so now I'm not hearing that speaker anymore.
Right.
I'll get the audio guys fixing it.
Around not using the house and using weapons.
Okay.
Okay.
Did we change it out on here?
They're messing with the audio. Give me a second here to get this right.
I don't think we were doing anything in here until the project.
We just did the move though. Remember we had to get rid of all of this.
Yes.
We're trying to get the right video running for you.
To someone.
Day 6.
Yes, I did.
Day 6
And how
is
are you able to
live.
attribute that bedroom to a specific?
That's the sound we want, but we need earlier. It's only given us an hour of the video from before. This is no bueno. Okay, so I see you laughing at me there. Who was that? Ritz? I see what you're doing there. We've got a problem. The live stream doesn't want to play the way I want to, so I'm going to try to take it from another source. There we go. There we go. I've always got a fail safe. So okay, we're going to start right there. We're going to take from channel 2 instead of 6. Okay.
And now let Murdoch stole it.
Okay, there we go. So this started a couple hours ago.
Are we going to address subject matter jurisdiction?
There is a preliminary matter that both the state and myself want to request. At our last trial, we had asked that witnesses be excluded from the courtroom and from talking about testimony amongst one another.
Julie Pulido just sent a super sticker with 20.
Love it, Julie. That's an amazing super sticker, too. Thank you so much for your support. You are absolutely amazing.
And so the parties would be requesting that the court enter that order again.
All right. Is that agreed?
That is agreed, Judge. We just wanted, because there hasn't been a formal order this time, we feel that an order would assist so that witnesses are understanding they should not do things like watch the live feed, etc.
To watch. Oh, okay. Anybody who is here as a witness, and attorneys will be obliged to advise those who later arrive as witnesses, we're not here now, that they are not permitted to be present in the courtroom during the giving of testimony.
So people need to get up and go.
And that will continue even after they testify until the trial has been concluded. And that would also include not listening to or watching any
this feedback is awful
on television or radio or internet or telephone or anything else. And as I say, the attorneys will be obliged to notify the potential witnesses, and also you may not, even after testifying, you may not discuss your testimony with anyone who has received a subpoena in the case or has been notified to be ready to testify. No discussion at all about your testimony until after the case is concluded.
Did have in the prior order 4 people were specifically allowed to sit in, even though there had been a exclusion order, and so I just wanted to be sure the court is remembering that and aware of that. And those are Celia Patterson, who's the individual who was testifying when we left yesterday, as well as Sadie Beecham, and then Kayla Petty and Christy Radatz Ortiz. All 4 of those individuals were exceptions last time, and they have watched large portions of the trial.
All right. Any comment?
No comment.
Okay. Otherwise, ready to start?
Yes.
Okay, so what they just did is they just invoked the rule. The rule is why witnesses are not allowed to sit in the courtroom. They don't want them to hear other people's testimony because it may change how they testify. So the judge just invoked that rule, said the attorneys, you have to let them know you're not allowed to be in here. If you're a witness, you cannot sit in the courtroom for other testimony for the entire duration.
A medical appointment at, I think it's 3:15. I'll verify that. Maybe 3:45. Thursday. And I will be gone for about 1 hour. Any question? Okay.
Thank you.
Good morning. Would you come down, please? Yep. Thank you.
Bring the jury. Okay, they're going to come down. We're not live yet, but we're on today's live feed. I am going to change the speed up a little bit so we can catch up. So if you'll hold tight with me just for a minute. Settings.
We'll probably break a little later for lunch on Thursday.
Okay.
And probably take a shorter time, too.
Okay, so this is today. This happened this morning. Now, it gets spicy early on. I don't know exactly where. Now it's ring the jury because it's the phone. I like that, Patricia. Don't know exactly where it gets spicy, but a lawyer's going to have to leave the courtroom, which is it's going to be fun. And whatever leads up to that, I think it's going to be amazing. I would have liked to see it in the Murdaugh trial. I think that would have helped a lot. But that's not how they presented it. They didn't invoke that rule.
Good morning, everybody. Mr. Griffey.
Did you want Ms. Patterson back to the stand?
Please.
So we were on cross-examination of Ms. Patterson.
I'm going to work the audio a little better today.
You're still under oath, ma'am.
Yes, sir.
This defense attorney leads with his chin. If he were to run into anything, he would hit the chin first, like a week before any other part of his body ran into it.
Good morning.
I'm going to show you what's been marked as State's Exhibit 54. These pictures, was that something that you provided to the district attorney's office?
Super sticker with 0.99.
Yes, these were also provided to news outlets. Yes, early on.
And you said, no, that you provided this to the district attorney's office.
That is correct.
In your direct examination, you were talking about how when you arrived on the scene on March 28th, 2020, that you had taken a video audio recording of your walkthrough.
Your Honor, I'm going to object. I believe the date's wrong. I think you said March 28th, and that's not listed in the testimony.
Sorry,
Thank you,
May
One Man's View,
28th?
for the super sticker. Appreciate it.
That is correct. When I was given access to my son's apartment on the 27th, I went in on the 28th. I went into his apartment and sat on his couch to gather my thoughts of what I was.
Judge, I'm going to ask that this be struck. It's non-responsive to my question.
Objection is overruled.
Ooh.
Go ahead.
To gather my thoughts as to what I was looking at, everything. And it took me a good while I was sitting, when I got up and I started to do my walkthrough. I did record and did an audio video recording of my son's apartment.
Did you provide that video audio recording to the state?
I did not.
And when you provided the other exhibit to the state, you did that. How many times did you meet with the state to discuss this case?
You know, you're using lawyerese, the state.
Sure. When you met with, when I refer to the state, do you know that to mean district attorneys?
I do.
Okay. So when you provided that picture,
you.
who did you provide that picture to?
Thank you, Lucky Team
I don't
Hogue.
recall.
Appreciate you gifting 5
how
memberships.
many times did you meet with someone from the district attorney's office to discuss this case?
The initial meeting back in December, and here recently, maybe about 2 weeks ago.
And when you met with them about 2 weeks ago, who did you meet with?
I'll correct myself. It wasn't 2 weeks ago. It was about a week ago. And I met with DA Gravely, ADA Jessica, and Heather, the victim witness advocate.
And did you discuss what your testimony would be?
Not really, not entirely.
When you say not entirely, what do you mean by that?
What I mean about that is expectations of what I asked the questions, what am I speaking to? And they said they really couldn't answer my question. They said that, the questions would come out at here at trial, but just to be prepared to speak about my son and his truck and the picture that Mueller just showed us.
Thank you for providing that little bit of background information. Now I want to take you back to around May 19th, 2020, and I'm sorry to have to do this again. On May 19th, 2020, you had said that you spoke with Eileen Knoll.
That is incorrect.
Who was it again that called you?
Kayla Petty.
Kayla Petty. And Michael Campbell, do you know an individual by that name?
He's a very good friend of my son's.
And did he call you on May 19th, 2020 before Kayla Petty?
No.
So you did not talk to Mr. Campbell on May 19th, 2020?
Not that I recall speaking with anyone other than Kayla Petty.
On May, you probably might not remember this, but on May 26, 2020, do you remember speaking with Detective Martin Howard?
I spoke with a few detectives, but I don't remember exact date or who they were other than Detective Correa.
And do you, though, remember talking to a detective about dental records pertaining to your son?
I do.
And do you remember telling that officer who his dentist was?
I did.
And had you been aware of your son's dental records? Did you ever know about, let's say, him having cavities and needing fillings?
Yes, I took him to his appointments with the doctor.
Okay, and to your knowledge, did Mr. Gutierrez have any fillings in his teeth?
Yes, he had fillings.
Thank you, Cajun Girl. Appreciate the super sticker. Fist bump.
And if you remember, and if you know, and you might not, there's two types of fillings. There's like the metal one, and then there's the composite fillings, which are meant to look like teeth. Do you know which kind he had?
I do not. I'm sorry.
This witness is very composed. She's doing a good job.
Do you remember speaking with detectives about, strike that, during your direct examination, you spoke to the state about, you kept saying your son's father. When you were talking in that capacity during direct, were you referring to your husband, Mr. Patterson?
That is correct. Rosario, my pocho's dad, was never in the picture. So when I say his dad, I'm referring to his stepdad, my husband, Eugene, who has been more of a father than his father was ever.
And do you remember telling detectives that your son's biological father had not been involved in his life since he was around 2 years old?
That is correct. When we separated and the judge asked him if he wanted visitation rights, he said he did not. He has never been in my son's life since my son was 2 years old.
And that you didn't have any information about where your son's biological father was, where he was living, what he was doing. You didn't have any of that information.
That is correct. That is something that weighed really heavy on my son, not having that father who wanted him. That's why he wanted to be the best father that he could be.
I'm going to hand you State's Exhibit 37.
Just for the record, for those that don't know, Team Hogue represents the best of LawTube. Big shout out to them. Amazing. If you know, I guess. Awesome. It's good people out there.
Okay, you went over these a little bit, but these are the Chase Bank records for the joint account with you and your son, right?
That is correct.
And so I want to draw your attention.
It's just warming up here. We just started for the day. This is today's
3 of 6.
testimony.
It's of the April 23rd, 2020 through May 22nd statement. It's kind of in the middle of the packet. Do you have it? Okay. So page 3 of 6.
I'm there.
Okay, thank you. In these records, do you notice anywhere where your son had made an ATM withdrawal?
I see them, one on the 14th and one on the 15th.
I think she meant withdraw.
Okay, and then you didn't, that was not you, correct?
That is correct.
And the one on the 14th, how much did your son, according to these records, withdraw?
It indicates 700.
And then on the 15th?
An additional 300.
So a total of $1,000?
That is correct.
And naturally, this was what we see in Exhibit 37. This was your bank account too, so you'd be able to access all of these documents, correct?
As he was mine, yes.
And in your reviewing all of these pages, is it a fair and accurate depiction of your bank statements?
It is.
Judge, I would ask to move in State's Exhibit 37.
Is there objection?
No.
The entirety or just the reference dates?
I think the just page, the one I referred to, I didn't really question Ms. Patterson on everything else. I don't mind about the entirety going in, but if the court has concern about that, then I would ask it be that specific page that I had been questioning the witness on.
Any objection?
You should object here.
I would just ask the whole exhibit go into evidence as opposed to parsing it out. There had been testimony on direct about some of the other pages, so I would just ask the whole exhibit.
It'll be received.
Okay.
Thank you.
It's incomplete bank statements, Aaron. I wonder if that'll come back to bite them.
I don't have anything else for Ms. Patterson.
Nothing, thank you.
Okay, so that's the mom of the victim. She ended yesterday and then finished. Well, she started yesterday afternoon and then finished this morning.
Meridia Macias to the stand.
Meridia. The judge did make the mom take off, or told her to take off the ribbon that was a celebration of her son's life.
Objection?
There's an issue about
Listen.
that we've raised pre-trial about Mr. Gravely being a witness to the interview.
Mr. Gravely being a witness.
The reason I always shoo you out of here is because it takes longer to unhook and hook her back up. And so it's easier for you to go out. So I apologize that I'm going to ask you to go out again. I'm going to go where you want. I'm hoping it won't be too long, but I'm not going to chance and make promises I don't know if I can keep. So please bear with us. Please don't read watch list when you come to the trial. Please don't discuss the case in any respect. And hopefully soon.
So this is where we're getting good. Mr. Gravely is the Steve Martin lookalike attorney, the white hair on the defense side. There's an issue with Mr. Gravely being a witness in this case.
They have the option. They can go in the library or they can go upstairs.
I just saw that.
Nicole, I just saw your tweet. I just want to take a peek here. I've seen some crazy posts. I'm not saying you're wrong. I just want to sort of authenticate everything.
Here's the thing that I would have never done.
All right.
Thank you. Judge, March 16th of last year, we went to trial in this case, you recall.
I do.
And
I don't think I'll forget so.
None of us will, Judge. So you recall the whole incident with his opening statement, and he talks about having a evidence. He's going to offer evidence about this Meridia Macias and an interview that he had, him and his assistant, had with her at the crime scene, which completely changed the time frame of the defense's whole defense. And So when we confronted him about it, you asked him, well, who was there? Well, his response was, and I'm looking at docket 73,
it's a no.
the transcript of the jury trial. He said that
Nicole,
there was members of the district attorney's office there. And then he was pressed further, and he said multiple people were there. And then I asked you to ask him who specifically was there, and he had finally admitted it was just him and his assistant, and that's all. And you ruled, well, you didn't ultimately rule, but you said, well, that makes you a witness. You took a statement. His defense was that he was not going to, create a report for every single witness that comes forward or everybody that he talks to in trial preparation. But he took a statement from this witness. He is a witness now. He's on our witness list. We have subpoenaed him. He's known this for almost a year. He should have taken himself off the case, but he didn't. So now we're at the point, and I believe your ruling was that we were going to wait and see if this witness actually testifies. We were going to see, how all that unfolded. Well, now it's unfolding, and it's right in front of us right now. And they wanted to call this witness, who they met with at the crime scene. And it's the whole issue about we went to the wrong building, and we used Google Maps, and all of this stuff. All right? So since he is on our witness list, he is subpoenaed, and he's well on notice of this for over a year, I'm going to ask you to remove him from this case.
He's on the
He is
witness
now a
list.
witness. He needs to be out of the room. He's sequestered. And then the state can call this witness. And then, during our case, we'll call him as witness. That's my request.
So if he's sequestered, he
Well,
can't,
Judge,
be here
I
for
want to
any
indicate
other...
what a stunt I believe this is. So first of all, the court had a pre-trial hearing about this where we argued this, and the court, at that pre-trial ruling, permitted the state to remain in the case and indicated that it was not going to remove the district attorney from the case. So we have actually had a ruling on this within the last several weeks. Then counsel, when this witness is called, brings it up and actually says in front of the jury as the description, so the jury gets a chance to hear it, that I should be removed from the case, that the DA should be removed from the case. Then they make an argument that is an identical argument to the argument made to you in that pre-trial ruling several weeks ago. There's no change at all in the argument. They indicated to you at that time that they had subpoenaed me, which is also a stunt, that they have placed me on their witness list, which is also a stunt. What the court recalls is the following. The court will recall that in that fateful day where this case was previously held for trial, I was asked a question mid-discussion, and by the way, I am the one who brought up to the defense after hearing their opening statement. I am the one who went to the defense and said, I guess that you should be aware that there was this additional supplemental information that we received. So this was something I told them after I heard their opening statement. I privately approached them and told them that. When we were asked about the details of that, the statute does not require that be disclosed. The statute specifically requires written and recorded statements. This is not a written statement. It is not a it's not a recorded statement. We had a meeting with Ms. Macias at the DA's office. That had present other members of the DA's office, including our victim witness persons who usually accompany us in those interviews. That's where we talked substantive information to her. Ms. Macias was leaving. We indicated to her as she was going to drive out that we would go to the same location so she could show us where she had parked over at the apartment building. When that happened, we discovered at that point that she had gone to the wrong building, and so that's how we found that information. We did not know that information until then. We asked her no follow-up questions that I recall. I don't recall any actual interview with her that took place there. We simply explained to her when we saw that, okay, now we understand this is the wrong building. And so that was all that happened. We didn't ask her how this occurred or any of those things. Present at that discussion, where we talked to her, was myself and Ms. Krzyzarek. For some reason, Ms. Krzyzarek is not on their witness list. I'll tell you that in terms of anybody who has a memory of that interaction, Ms. Krzyzarek is somebody who has a memory of that. I barely remember that interaction. In fact, I think that's very clear in the discussion that counsel just provided the court. When I was asked who was there, my thought process was that certainly victim witness was there. When I turned to Ms. Krzyzarek and asked who was there, she is the one who said to me, it was just you and I. I didn't have an independent memory of that.
I can't tell them who they can name as their witness.
I understood. I understand. I'm not saying you can. I'm simply indicating that the way that was then remedied, the court allowed us to talk about whether there would be a mistrial in this case or not. The defense asked for a mistrial. The court was assured by all the parties that this would be a mistrial that would be done without affording any misconduct to any of the parties involved in this case. And so we agreed to a mistrial rather than asking that the court continue at that time. So this was a mistrial that both sides agreed to afford the defense an opportunity to have that information, particularly with whatever issue the court might have in terms of us being a witness. What we then did was remedy it by having Detective Correa, who's sitting with us here, go with another detective, not with anybody from the DA's office, to the location and have Ms. Macias actually explain, without the DA's office being present, where she parked, where she was vis-a-vis that apartment building. So there is a recorded statement of that done on body cam, and that is done so that the defense can see nobody from the DA's office is involved in the collection of that information. It's obviously post that original meeting, but this has taken place. So again, I don't know what we're discussing that was not discussed a couple of weeks ago before this court.
Well, what we're discussing is the only stunt here is Mr. Gravely misrepresenting to this court what actually happened. The fact is that he went out and met with this witness months before trial, didn't tell us anything about it, and then made it a prominent part of his opening, is the point. That wasn't like a little thing. It was a very prominent, and you even said that, it was a very prominent part of their opening, and then he is completely evading his responsibility about this being a statement. He says it's not a statement. You even corrected him, and I'll point directly to docket 73 at page 31 to 32. That's a whole discussion about the court asking Mr. Gravely, who was down there? Multiple people were down there, he says. I want to clarify for the record. And you said, it was not my impression that Mr. Gravely was physically present, and he finally admitted that he was there. And so this whole thing about how we're going to remedy this by sending Detective Carrera out to do that, that's not the remedy, okay? The remedy is to have him leave this case and have them, if they want to call this witness, have them then call the witness, and then we'll call Mr. Gravely after we cross-examine her about her interactions with him, and then we'll get him on the record about what his interactions with her was.
Amber, thanks so much. Appreciate your support.
Today, how many other witnesses went through the same exact process with the district attorney's office?
I'm going to talk about things I don't know about.
Okay.
That I do not let it here.
Why are we litigating the same thing we litigated 2 weeks ago, other than that we're on national TV? Other than that, what is the possible reason for this to be brought up now when the court made a ruling a couple weeks ago, Judge?
The judge did not make a ruling, Judge.
Just a minute. If I know...
I like it.
Usually, this type of thing, I would not have made a definitive ruling. I would have said, as the situation stands now, and I would have pushed it off to see, and in fact, my sentiment is right now, I think I'm probably going to push it off to see if we need to, if I do have to make a definitive decision, or if it's one of those many things that we encounter in life that are problems that may just go away.
My actual ruling was, Judge, that you were going to wait and see, as you typically do. You delay a final decision. You tell us like what you're thinking, but in this case, you said, well, let's see if she shows up. Well, she's here.
Well, and let's now I'll make the next move and say, it's like a chess game.
Appreciate your support. Thank you so much.
Let's hear what she has to say, and maybe the problem will evaporate. Maybe it'll diminish. Maybe I'll decide it's really not a problem at all. Or maybe I'll have to take some action. If I do take some, first I'm going to take one action right now. You can't examine her. Ms. Krzyzerek can examine her. No.
Judge, I'd like the court to take a look at the minutes from the...
I don't know, if you're going to quote what I said at the last time, you don't need to. I'm saying you're not going to examine her. Without doubt, we're in a perilous area.
Jury's not here.
And we've got 7 days into this trial. Well, actually 9 or 10 when we count the last time. So this is a perilous area. I don't want to get any closer to the edge than I have to. And Ms. Krzyzerek is a very competent lawyer whose assignment to this court I think I enjoyed for 4 or 5 years. And I'm quite confident that she'll be able to handle this issue. And I'm not saying you're off the case. I'm saying she will handle the examination. And then I will await further developments before making a decision on the rest.
Regardless of what the court's role is in this, Mr. Gravely has an independent obligation as a licensed attorney in the state of Wisconsin to recuse himself from the case because, by definition, he's a witness, and by the ethical rules say you cannot be a witness and a lawyer in the same case.
Show me that rule. You can't argue the case to the jury. When I last looked at the rule, it was you cannot argue your own credibility. That was the basic rule. And that's actually why even though I'm going past that, why I stated Mr. Gravely can't examine the witness. But take a look at it. and pointed out to me.
So show me the rule.
Can I ask if the attorneys involved here who have an obligation to report ethical violations have reported it?
No, you can't, because they're not here to be examined on this issue. And also, if I can tell you, it happens very, very rarely, but when I've had serious ethical violations happen here, usually I handle them with a rebuke, occasionally with a mild censure, but I have on occasion reported people. I commented at the time of the initial trial that while I thought Mr. Gravely had made a mistake, I did not think it was purposeful misconduct, and nothing I've heard since has changed my mind about that. And so I'm not going to report it.
All right. So I just want to be clear, because this record is now is here. It's my belief that what the court said at the prior hearing was that you did not find that there were sufficient facts in the motion or in the argument to remove a sitting elected district attorney from a case of this type. I asked the court to review the report provided by Detective Correa, who indicated what was said, and the court, I believe, indicated that there was no reason to believe that there was a prior inconsistent statement that would make anybody a witness at this point. So that
defense called him as a witness.
Witness is now available as to the circumstances of this, that was what I understood the court to do. So clearly, I've been in front of the court a long time. I heard the court make a ruling, and we proceeded accordingly because, of course, we were a couple weeks from trial, or a week from trial. I'm not sure exactly what the date was, but we had a special hearing on this. And the court ruled. I am, in fact, quite surprised that this has been brought up again based on what I heard the court say that time. Not because attorneys can't bring things up again, I suppose, but we heard the court make a ruling. I thought it was guidance to us on the state being able to proceed without any fetters on it. The court is making a slightly different ruling today, and I don't know.
You know what? I am not going to have the reporter go looking for the transcript or the notes, and then have it go from there, and then everybody wants a transcript and so on and so forth. I think what I said was clear.
Okay. I just want to be sure I had a chance to respond, but I did understand.
I think it was clear what I'm saying today. And I don't know that I would be very surprised if it's inconsistent with what I said last time, especially when I'm quite sure, as I almost invariably do, I gave you a sentiment as to what I was thinking, but specifically probably told you it was not a final ruling. What did you want to say?
So Supreme Court Rule 20.3.3, the ABA Comment 2 makes it clear that that officers of the court, to avoid conduct that undermines the integrity of the adjudicative process, when you're a witness, that the prosecutor cannot simultaneously prosecute a case and be a witness in that case. And you can also take a look at United States versus Schwartzbaum, 527 F. 2nd 249, which was a Second Circuit case in 1975. But also the Wisconsin Supreme Court to address this in State versus Jorgensen, 2008, Wisconsin 60 at paragraph 38. Testimony from a prosecutor is difficult enough to overcome, but it is impossible for a defendant to test or counter a prosecutor's, quote, testimony, end quote, when the defendant is denied his right to confront the prosecutor as a witness. So that is directly on point with this situation, and I think that the attempts to muddy the water about the history of this by Mr. Gravely is just more testament that he needs to be examined about his interview with this witness.
Well, I want to take a look at that rule. What's the rule?
I'm sorry? Rule 20.3.3. And all of these sites are in our filing where we asked for him to be disqualified, which is document 77 of the record in pages 13 and 14.
Well, first of all, there's no reason for me at this point to believe that there is going to be any inconsistency in the testimony of the witness and Mr. Gravely's account of it. And I understand we don't have him having given an account, although you could have asked the court for authorization for a deposition or something, but I don't want to get into that discussion.
The defense called the DA as a witness, and now they've just invoked the exclusion rule so that witnesses can't be there when anyone else testifies. And now they're like, oh, by the way, reminder, he's on the witness. Can we kick him out now?
20.303?
That's what we've got down here, but I'll look it up with you.
One of the problems with the audio in the courtroom is each table has a microphone and a speaker. So the speaker is supposed to make it so they can all hear, but the microphone is in front. It's like placed in front of the speaker, so we get this feedback loop. It's awful. I wish they would hire somebody like me to come in and run their audio, because I'd change it and everyone would be able to hear, and it would be beautiful. This is why we're watching this trial, because this is like this is not done. This is not the last shenanigan we're going to see on this case. A little bit of desperation. It does seem like a cheap move. He was called on as a witness because of what he did. He interviewed somebody, and he and his actually the assistant DA are the only two who were there. So they're witnesses in the trial to an interview that they had with another witness.
You look at 20. It's not point. It's 3.7 lawyer as a witness.
Steve Martin v. Phil Silvers. It's a mad.
The lawyer should not act as advocate at a trial in which the lawyer is likely to be necessary to be a necessary witness, unless the testimony relates to an uncontested issue, testimony relates to the nature and value of legal services rendered, or disqualification of the lawyer would work substantial hardship on the client. The lawyer may act as an advocate in a trial in which another lawyer in the lawyer's firm is likely to be called as a witness unless precluded.
Yeah, he's the elected district attorney. It's a political office. He's like the top dog. Thank you very much, Lee. Sorry, I slipped into the old habits. Lee. I appreciate that. Steve Martin versus Phil Silvers. It's a mad.
Well, 3B, 3 sub B. A lawyer may act as advocate in a trial in which another lawyer in the lawyer's firm is likely to be called as a witness unless precluded from doing so by 20:1.7 or 0.9.
State's still in the middle of their case. They have not rested. They're about to call a witness that was interviewed by the DA.
And then under comments, number 2, the tribunal has proper objection when the trier of fact may be confused or misled by a lawyer serving as both advocate and witness. The opposing party has proper objection where the combination of roles may prejudice that party's right in the litigation.
Yes, he's been on the actual witness list. This is not a new ad. They knew this, and they've talked
I've
about
already
this weeks
stated
ago.
over Mr. Gravely's objection that I'm not going to permit him to examine this
He should
witness,
also not be allowed in the
witness.
room at the time during the examination.
You could probably talk me into that. But what in the rules precludes Ms. Grzerek from handling the examination of the witness?
No, I think she can.
Now, I did refer to what was also an ancient rule. I know I define it as ancient because I was taught it in law school. And it was that the lawyer can't argue his own credibility. I'll forewarn you parties now that if credibility is an issue, and it may not be, in fact, maybe Mr. Gravely won't even see the witness stand. But if credibility is an issue, then I probably won't permit him to argue the case either. But that, to me, it seems like the outer limits, if we get to that point.
Credibility of who?
Well,
credibility of who is an issue?
Well, that's a good question. I guess I'd have to be, if your credibility comes into issue, or if there's an inconsistency of any kind between your recollection of events and that of the witness here, that I think you're probably going to be precluded from arguing anything about the case. But let's push it on.
So, just a question, so I can orient myself. I was obviously also present during the interview with Ms. Macias that day.
But you're not on the witness list.
Right, but if then the next tactic or stunt becomes, well, now, say Mr. Gravely eventually has to take the stand, which shouldn't happen because it's not an inconsistent statement, but let's play hypotheticals. So then Mr. Gravely takes the stand. He's already made it pretty clear that his memory is not necessarily sterling, which is why at the previous hearing he did lean over to me and ask me who was present. So if at that point, hypothetically, he takes the stand and doesn't have clear recollections because that's the status of the world given what he does for a living, then are they then opening the door to then trying to call me to the stand as well? Because I would have the better recollection.
Is this legal jeopardy?
It's the next logical jump in.
I don't want to get into next logical jumps. I've said what I have to say at this point, and that's where we're at.
Judge, first of all, none of this is a stunt.
I don't want to get into
the defense didn't create any.
Jury's in the back room.
Okay. The point is that the issue here is that this witness, this critical witness, significantly changed her story from all the reports we had before that February trial from last year. And so, and those two prosecutors were the only two people with her when she did that.
And I said last time I thought that was a mistake.
Yes.
And I granted a mistrial because I thought it was a mistake.
That's the mistrial.
Contrary to Mr. Gravely's representation, while the defense agreed to a mistrial, we were forced into it because of that exact flow of events created by him. So I just want that to be clear, that this is not something that the defense cooked up. This isn't a stunt.
I don't want to hear any more. There have been jibes periodically throughout the trial, and I've had as much as I want to hear. I want to get this case put to the jury and a true and just verdict reached. Okay? Any question about what the rule is now?
I understand the court's ruling, Judge. Could I just have 5 minutes to reorient myself with the exact exhibits, since this was anticipated to be Mr. Craven's witness? Thank you.
And you were ordering him to be out of the room during this examination?
Again, I would object, Judge. As the court knows, I'm acting as a steward of the evidence and the discussions in this case. I intend to make an argument in this case at the end. For me to not be able to watch this key witness is not appropriate. It's no different than Detective Correa, who is a case officer and will testify in this case.
I will permit you to watch the video of the testimony before argument, if you are going to be arguing.
So out he goes.
Okay,
and I'll even let you listen to the audio.
Yeah, I'm going to ask that the court not have the jury have the specter of me not be present. The court has not found that I engaged in any misconduct.
I am going to give a brief instruction to the jury that our attorney rules have provisions about lawyers on the case testifying, and for that reason, I've asked you to step outside the room. I'm not going to say anything assessing any fault or any misconduct or mistake.
Here comes the walk of shame. He's going to have to get up and leave.
Just to explain to you them why you are not in the room. Okay.
All right, so 5 or so minutes.
With the emphasis on the 5. Okay. Would you tell the jury it'll be about 5 more minutes? Thank you.
Broadway Garden. Oh man, Ivan, I did reach out to Ivan, guys. You asked me to. Ivan says, "Don't worry, y'all. I'm okay. Quarterly inventory week at the store, which is my arch nemesis. I'm lurking in the background as always." Ivan, good to hear. I interrupted you and messed up your count. Hopefully everything's there, nothing's missing, and it's all good. Appreciate you. Thanks for being here. Defense is like, bye, Felicia. Yeah, it's very much. It comes across as a little bit petty, just a tiny bit petty. They are playing the game, but the whole court case is it's not one big battle. I mean, it is. There's like a single outcome that they're working towards, but that outcome is achieved by a whole bunch of little battles that have an impact on how the big battle is decided. And so you've got these little battles, and this is a win for the defense. Nicole, sorry, not Nicole. Nicole's right here. I'd rather be day working says, I think the judge's ruling is good. The defense is always going to do anything in their power to get the client off. Yeah, I think they're right. It is a bad day in court when the DA basically gets kicked out of court just for this witness, though. It's not, at least right now. I don't know what's going to happen tomorrow, but at least right now, it's not for the whole time. I'm going to skip. Well, looks like a judge is back here. Can we bring some audio up, please? I was going to skip ahead. Oh my goodness. So Zachary Anderson is 40. Let's see. I think he's 42 right now. Thank you, Amber, for the tweet, the link to the story. Can we give the defense 2 points for pulling this off? Yeah, this was a win, but really it's not going to mean a lot. The jury didn't get to see this. It's mostly more of a slap to the face of the district attorney. And it's like, yeah, Vixen, you're right. Amber, you're 100% correct. This issue, the reason they had the mistrial last time is basically the result from that is what they're talking about here. They got a mistrial because the interview of this witness changed her story completely when she was in the presence of these two DAs, the DA and assistant DA, and then the defense was never notified of that. So there's a discovery violation, everything. It was forced into a mistrial, and now we still have to try the case again. And we have this situation that's like, hey, by the way, this interview, this time they spent together type thing, it's an issue. And so now they're not going to allow Gravely to question this witness, this particular witness. Will they? They'll call him on the stand and ask non-important questions just to put a cherry on top. I think they will. I think they're that petty. Especially if they start losing, I think they'll do that. $3 million in product account. Oh my goodness, Ivan. I used to do inventories at the metal building shop that I used to work at. Metal Building Components Incorporated was the company, MBCI, and we had to count every pop rivet, every screw, every bolt, every beam, every sheet of metal. It was awful. It's not fun. When you've got millions of dollars in inventory, it's not good, and when it weighs millions of pounds, it's even less fun. Let's see, defense isn't the only one playing games. No, they're both playing games. Will Leno testify? I got the Leno reference there. I don't know. I don't think they should. It's not like he has really. I don't think there's a reason he would be up there unless they just want the spectacle of putting him up on the stand in front of the jury. The more I watch this defense lawyer, the more he reminds me of the mafia. Brooklyn says a witness stated they went to the victim's house and were supposed to meet him, but he never showed up. Yeah, he went to this other place or something. I'm still waiting to hear the facts of the matter as it gets developed in front of the jury. Do you know if the lady defense attorney was appointed or hired by the defendant? Hired. Carol, we know that because he had like $46,000 in cash on him when he was arrested. And when you have that much cash, generally you don't qualify for a court-appointed attorney. Now, the cash may have been the ill-gotten gains of his marijuana growing operation, which had by some accounts was worth close to $75,000 per crop. Let's see, if the prosecution had eaten their spicy bourbon pickles, they would have seen this coming and won. Yeah, they talked about this a couple of weeks ago, and apparently they just assumed that everything was good. That the judge saying, "Oh, I'm not going to make a ruling on that," just meant that there's not going to be a ruling ever on that. Well, the ruling today was that Gravely can't even be in the courtroom, and he'll get to watch this video tonight in his hotel or wherever. Let's see, Chandra, thank you. Got to step away. Appreciate you. I think we've lost to Samantha and Chandra have to step away. Two of our great mods. We're putting the extra burden on the remaining mods. It is a strategy to throw them off the game. 100% agree, Nicole. It's not factually. It's not going to make or break the case either way, but it does. It makes me happy. It's a low blow. It's a cheap, but it's done using the rules. Okay, so it's when there's like bad rules or something. No, it's a good rule. It's a good rule. Imagine being able to legally get a low blow in boxing. Okay, that's what they just did. They got a legal low blow. Let's see. Are we still catching up? We are. We're still catching up. I'm trying to skip. I was going to skip ahead, then I got sidetracked talking to you guys. So let me. Looks like we're back already. I've done skipping ahead. We are playing at still at 1.25 speed, so we're trying to catch up. And if we skip the breaks and the lunches, I think by the end of the day we will be really close to being up to speed, up to the live. DA has been baiting the defense by asking leading questions and making them object so they look obstructionist.
All right, Ms. Krizarek?
They haven't asked. They haven't made nearly as many objections as they should have. And look, there he went. He just walked out. He waited till the very last minute to walk out. And we get to see his shoes. As he buttons up his suit coat, slams the door on the way. Should have been pretrial. I agree. This is definitely a pretrial type issue.
Would you raise your right hand, please? Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? Please be seated.
Ma'am, could you please state your name for the record and spell it?
Nereida Macias, N-E-R-E-I-D-A, Macias, M-A-C-I-A-S.
And are you currently employed?
Yes.
And how are you employed?
I work for the circuit court as a clerical specialist.
And in what city?
Milwaukee.
And back in May of 2020, did you on a dating app meet Rosalio Gutierrez Jr.?
Correct.
And what dating app was it, if you recall?
Facebook.
And do you recall generally the date that you first connected with Mr. Gutierrez Jr.?
The date? May 12th.
And did you begin to exchange messages with him starting approximately May 12th?
Correct. Objection leading.
Sustained.
Here come
Did
the
you exchange
objections.
messages with Mr. Gutierrez?
Correct.
And in general, in the early days of May 12th through the next couple days, what generally type of things were you talking back and forth about?
Religion, spiritual stuff, like self-help information, books about his mother, his kids, his job.
Were you getting to know each other?
Correct, yes.
And up until May 17th of 2020, had you met Mr. Gutierrez at all?
No.
In fact, have you ever met Mr. Gutierrez Jr.?
No.
You indicated that you and Mr. Gutierrez Jr. talked about family and different things like that?
Yes.
What's important to you in life?
Objection, relevance.
Seems marginally relevant.
I would agree.
It's
Very marginally. So if it's short, I'll...
Very brief, Judge.
Okay.
So ultimately, did you and Mr. Gutierrez Jr. make a plan for May 17th?
Yes.
And did you do that over the phone via text messages?
Yes.
Now, prior to May 17th of 2020, did you know where Mr. Gutierrez lived?
No.
I'm going to direct your attention to the television screen. And this is on State's Exhibit 1, number 344.
This is the other side chick that
Ms.
the
Macias,
victim
do you
had.
recognize this phone number up here at the top?
Yes, that's mine.
Okay. And would that be a nickname for you as well as your last name?
Nettie, yes.
Okay. And do you recall asking this question of Mr. Gutierrez Jr.?
Yes.
And what is that question that is up there?
What town do you live at?
And he then responds with Kenosha. Is that accurate?
Yes.
And he then gives you a little bit further information. I live right by UW Parkside.
Yeah. Yes.
Now, at this point, were you developing a plan for you to come down and meet him?
That day, yes.
And do you recall if there were suggestions about different things that you guys could do, given the status of the world back in May of 2020?
What do you mean? I'm sorry.
Well, let's move on to your next message. Does it read, "What's open" from you?
Yes.
And then you ask around by you? And he responds, "All the Kenosha bars are open." Is that accurate?
Yes.
And do you recall your response being, "We are not going to a bar"?
Yes.
And why is that?
Because going to the bar, obviously you're going to drink. I'm not going to drink and drive, only because of where I work at.
And ultimately, what did you guys decide would the plan be on May 17th that evening?
The plan was to pick him up and go out, I don't know, just drive around and get to know each other, basically.
And so as part of that plan, did he text you his address?
Yes.
I direct your attention back to the screen. This is now page number 151 of State's Exhibit 1, number 344. And would the address that he texted you on May 17th at 6:58 p.m. be 3709 15th Street, apartment 1B? Is that what he texted you?
Yes.
Now, once you had that address in your phone, what did you do to look up where he lived?
I looked it up on Google Maps to see where exactly he lived. It did, in the beginning, kind of scared me because I wasn't sure if it was a good idea to go or not. But his personality really caught my attention. So I went for it and drove out there. Here.
And
So this is a girl the victim also was dating or wanted to meet.
showing you that same exhibit again. This is specifically page 149. So at approximately 6:56 p.m., he tells you, no worries, take your time. I still have to drop off Ava, and she lives 45 minutes away. Is that accurate?
Yes.
And you respond with an okay?
Yes.
Then is it you that sends him a message saying 8:30 or 9?
Yes.
With some question marks?
Yes.
And he responds 9 will be safer?
Correct.
And you say okay?
Jury instruction didn't happen to the best of my knowledge.
And then we get into where he gave you his apartment address.
Yes.
And then did he give you the full address at approximately 8:15 p.m. on the 17th, including Kenosha, Wisconsin, 53144?
Yes.
At some point, does he tell you that, according to his GPS, he'll be home at 9:01 p.m.?
Yes.
Direct your attention back to the screen. And as your conversation continues, at approximately 8:25 p.m., does he tell you, see you soon?
Yes.
You say back K. Is that accurate?
Correct, yes.
Then he asks if you want him to pick you up anything to drink, Corona, Bacardi, or Jameson.
Correct.
And you indicate you'll settle for a beer? Does he then indicate to you other drink options?
Yes.
And is your response water is perfect?
Yes.
And then I don't want to get a DUI? And he then texts you, I understand.
DUI would mean she has to go into work.
Yes.
She works at the court.
So
Charlie,
after
thanks for the gifted
receiving
membership
that last
to
message,
Carolina.
do you then proceed down to Mr. Gutierrez's residence to meet him for the first time?
Correct, yes.
And what map program were you using, if you recall?
Google.
And so did you put in the address he had given you of 3709 15th Street 1B into that map program?
Yes.
And then were you texting him updates about your progress?
Yes.
So I'm going to show you once again up there. We left off with him saying, I understand, at 8:27 p.m. And then at 9:37 p.m., is that you indicating you're 5 minutes away?
Yes.
And then at 9:43 p.m., indicating I'm here?
Correct.
It's not a
And then at 9:44 p.m., asking where do I park?
Yes.
And at 9:52 p.m., are you okay?
Yes.
And at 10:05 p.m., I'm worried about you, are you okay? And then at 10:18 p.m., indicating I left. And I'm going to scroll back up to the top of page 158. After Mr. Gutierrez has sent you, I understand, and it says delivered. When looking at your messages, what is the status of each message that you send after that, if you can tell?
It says unread.
And that's on each of these are unread?
Yeah, it says unread.
Jesus. It says unread. Unread.
So after 8:25 p.m. when he texts you, I understand, do you hear anything further from Mr. Gutierrez Jr.?
No.
To this day, have you ever heard anything further from Mr. Gutierrez?
No.
Now I'm going to show you a map of the Wood Creek apartment buildings.
Nicole, what coins
Now
are you
when you
hunting?
came down to
quarters?
meet with Mr. Gutierrez, can you, with a pointer, Judge, can I get the pointer from you? Ms. Macias, if you could take this pointer, and can you go up on this map and explain when you came into this apartment complex, where you went, and then what building you parked in front of?
I'm sorry. I pulled in through the driveway, and I parked right here.
And is that where your GPS took you to that building?
Correct, this building.
And when you first pulled in and parked right there, what did you do next in front of that building?
I waited a few minutes because I was nervous. I really wanted to get to know him. So I figured the door is like right here. So I pulled in a little closer by some dumpsters, and I waited there for a couple minutes more.
And do you recall what the weather was like that night?
It was like drizzling. It was kind of like rainy.
Okay. And obviously you got there at sometime around 9:30, 9:45 p.m. Was it dark out?
Yes.
And so besides parking in those locations you've talked about in front of that apartment, what else did you do, if anything?
Since I wanted to see when he came out, I parked across. I saw a guy that moved out his vehicle, so I parked right in front of the door so I can see when he comes out, and I can just kind of flash my lights. But he never came out.
And ultimately you then left the area and went back home?
I waited there a few minutes, but he never came out. So when I pulled out, I ended up parking right here. And I kept texting him, "Are you okay?" I don't know if he was in the shower or married. I did not know, so I left.
Shower or married? Are those the two options? He's either in the shower or married.
Now, prior to that night, had you ever been to what is commonly here called the Wood Creek Apartments before?
Never.
Were you familiar with this area of Kenosha?
No.
After giving that statement to law enforcement about your interactions with Mr. Gutierrez that night, do you recall having a further meeting with Detective Correa in March of 2022?
Sorry, Georgia.
Yes.
And what was the purpose of that meeting, as you best recall it?
To talk about what exactly happened at the location.
And what type of questions did Detective Correa ask you that you can recall?
Where my GPS guided me to exactly, and how long was I waiting between pulling out my vehicle.
And did he ask you essentially a lot of the same questions I've asked you today?
Yes.
Now, back in 2020 when officers first spoke with you, did they have you come down to the scene and talk them through anything?
No.
So how did they where did they interview you the first time?
At the Kenosha police station. I actually came from Milwaukee because I saw on Facebook. Since I was not friends with Rosalie on Facebook, I was kind of curious. How come I didn't hear from him Sunday, May 17, 18, 19? I didn't hear from him, so I looked on Facebook, and it said, "Have you heard any information from Rosalie Gutierrez? Please report to police." So I drove down personally to speak with Kenosha police because I was concerned. And then I spoke with the detective, and I explained to him what happened, or was everything okay? And he asked me some questions.
And when you first spoke to Detective Correa, he didn't take you to the scene to walk him through anything?
No.
But the second time you spoke with Detective Correa, you actually went to the scene to walk him through exactly where you parked and what you had done.
Objection, leading.
Whoa.
During your second interaction with Detective Correa, did you actually physically go to the scene? In terms of where you parked?
Yes.
Did he share with you that the building you actually were in front of was not 3709?
Objection, leading and hearsay.
Stand.
The building you pointed to up there, that's where your GPS took you that night?
Correct, yes.
Now, I know that you had testified a little bit earlier that you had only been speaking with Mr. Gutierrez Jr. for approximately a little less than a week. Is that accurate?
Yes.
Did anyone in your life know anything about him?
No.
Had you been talking to him about him to family and friends or anything like that?
No.
Was there anyone in your life at that point that would be jealous if you were talking to someone on Facebook dating apps?
No.
Last question. So since 8:25 p.m. on May 17th, when Mr. Gutierrez Jr. texted you back, I understand, have you heard from him at all?
No, not at all.
I have no further questions. Thank you. Oh, ma'am, you have to, sorry, they get a chance.
She's like, I'm out of here.
And I'm just going to grab the cord.
Well, here goes the cord. Let's see what's going to happen here. It is getting a little juicy. This woman probably had no idea that the victim was already in a relationship. And Nicole, collect capped bust, 50 cents, shields and V nickels, colonials mostly. I'm compiling an uncirculated CB collection. That is awesome. I prefer just Indian head pennies. Those are my favorite. Love them. So you probably don't want Doug coins though. Doug coins don't get graded for some reason. Nobody likes the metal detectors.
Gutierrez gave you his address, that you put it in to Google Maps. Do you remember that testimony?
Yes.
You're standing by that testimony?
Yes.
You sent Mr. Gutierrez a screenshot of you putting his address in, correct?
Yes.
Interesting sounds. I wonder what's happening. Cameraman, I wonder what's happening. This is the point where they should switch cameras so we can see what's happening. But apparently no.
Judge, sorry, there just seems to be some connective issue.
Well, it's weird because it flickers on.
Okay, it's a cable issue. I hate to call you out on this, but we happen to have our own expert here who needs to go ahead and take care of this. Who owns the internet today?
Oh my gosh. Do we have another one?
Do we have a spare HDMI cable? This is interesting. The maybe Gravely took the cable with him when he got kicked out. They want to accuse him of manipulating the witness in front of the jury. Yes, that'll be amazing to see. Do you think there'll be an objection, Nicole? Do you think there will be an objection? I think everything they say to him, if they put him on the stand, will be objected to, and he's gonna be like, I wish I could speak, but his underling will have to handle the objections. We are not quite caught up now. We're a little bit behind. We're on today's video. So this is what happened this morning. But we've taken lunch already, and they have not. So we're just a little bit behind. Amber, the only mod left. We have a couple mods in name only, right? The jurors are missing all the fun. No, they need to call this witness. This witness has basically text interaction with the victim at the time of his death. Was supposed to meet with him, and he stopped responding. So this is important information that helps pin down exactly when this happened or when he went missing or stopped responding. So it's important for the state to bring it out, but we'll see what happens on the cross and just where the defense wants to go with this, how dirty they want to play.
Please don't talk about the case during the break. But
on your feet.
10 to 15 minutes.
Okay, we're going to skip that 10 to 15.
You can come up and stand.
Alex Stolen.
No, I'm on the wrong. Forgot I was playing from channel 2. Just 1 second here. Let's wait till they leave, make sure there's nothing happening. Oh, that swivel chair just spins. Look at that chair. That is fantastic. Okay. So we're going to go to... I forgot messages. We're going to catch up just a little bit. This is the hardest.
Bring the jury.
Okay, 410. Okay, we're going to start right there. Okay, I need to... Let's see, we're at... I think they're about to come back in. Yes, we're going to be caught up here soon. That was not bad. Not bad. We are still going at 1.25 speed, just to catch up a little faster. There were a few cuss words, I think. Alex stole it. Yeah, Rando, I had a security clearance that prevented me from doing anything that way. Oh, that was a really old message, Rando. Sorry, I just scrolled up to the top.
Go ahead, Ms. Muller.
77 cases of Windsor. Is that like a weekend supply?
Exhibit 344, page 153. Ms. Macias, this is the text message that you sent to Mr. Gutierrez with the screenshot of your maps, correct?
Yes.
And you had an iPhone, correct?
Correct.
Apparently he had an
I'll show you
Android.
what's been marked as Defense Exhibit 237. This is the screenshot that was in that text message, correct?
Yes.
And in this, it's your address to 3709 15th Street. And it's saying that it's going to take a total of 37 minutes. Sorry, if you could just say yes or no for the
my apologies.
recorder.
Yes.
And this screenshot is actually from Apple Maps, correct?
That's Apple Maps?
So you didn't use Gmail, you used Apple Maps.
Google Maps.
I used Gmail and Apple Maps. I don't know if it was the second time when I went out there to meet with the detectives, so it must have been.
So I must have used Apple Maps to meet up with him, but I must have used Google Maps to go see the detectives to meet up with them for the scene.
Okay, so when you went on May 17th, 2020, you used Apple Maps.
Okay.
Correct?
Yes.
Okay.
There's a sale on Windsor.
It would take you 37 minutes according to
at
Apple
Ivan's
Maps.
liquor store,
Yes.
apparently. He's got a few cases.
I'd ask that Defense Exhibit 237 be moved into evidence.
Any objection? No. Proceed.
Myra, that's basically what we're hearing.
Correct, thank you.
She might have actually seen,
It was on a digital
seen the attacker.
It's just taken. So, in your text messages, you and Mr. Gutierrez had agreed to meet at 9 p.m., correct?
Yes.
And you sent that screenshot that said 37 minutes. And do you remember texting Mr. Gutierrez at 8:24 p.m. that you were going to start leaving your house?
At 8:24?
Correct.
It's around 8, but I can't remember the times. I need to see the times. Sorry.
Pull up what's marked as Defense Exhibit 236.
Hey, Big Sky, you can throw it in chat. We just ask whatever it is, as long as it's nice and civil. If you've got a question or a concern, if there's some drama or something that's giving you problems, we'd ask that you don't put it in chat. You can reach out to me on the burner phone if you want, and I can address it that way. But we just want to keep chat nice and happy. If you need the burner phone, you can always type !burner in there. That is a phone that goes straight to me, and yes, it's actually my phone. Steve Martin, Jay Leno / lookalike will be allowed back in once this witness is done. That's what our understanding is. Here comes the spoiler.
Okay, so the message in the blue is your message, correct?
Yes.
Okay, and you send a text that says, okay, no worries, I love driving, it'll give me time to jam more, I'm going to start leaving my house. That was at 8:24, correct?
Yes, yes.
And your plan was to meet at 9, correct?
Correct.
So 37 minutes from 8:24 would be around 9 p.m., correct?
Correct.
A little after.
Now, in your text messages and in your direct testimony, you said that you're there, I'm here, at 9:43 p.m., correct?
Yes.
And prior to that, you didn't text Mr. Gutierrez that you were running 40 minutes behind, did you?
No, I did not.
You didn't call him and tell him you were running behind, correct?
No, I did not.
And he didn't call you asking you where you were, correct?
No.
And he didn't text you asking where you were.
I'm sorry.
Is there an answer?
No.
Could we have the witness speak directly into the microphone? We can't hear her at all over here.
Is it on?
Is there an answer? Are you answering no, there was
Oh, I was
not
saying-
an answer, or no, that was the answer?
No, that was the answer.
No was the answer.
Yes.
To the first question. Okay. Then speak into the mic, please.
So, you also testified about how it was your plan to drive around to meet up, you come and you drive around?
Yes, to get to know each other. I was too afraid to go to his house. I didn't want to go in there. I just wanted to basically get to know him and just get to know him a little better.
She just broke the
But
stand.
you didn't text about that plan, correct?
No, I did not.
You didn't talk to him that day about that plan, correct?
We did earlier when we were actually talking, when I was working.
On the phone?
Correct.
So what was the plan then for when you got there? At 9 p.m., what was the plan?
Don't know. We just wanted to get to know each other once I got there and see what was the plan. Either go to a bar, to a restaurant.
Well, I'm asking more about the specific details of your plan. You said that you were waiting outside for him to come out. Did you talk about that he would come out to meet you?
I think his plan was maybe for me to come in, but I would not go in there. My plan was just to sit outside, maybe in the car, and just get to know each other.
So his plan was for you to come in, but your plan was for him to come out?
Correct.
So what plan did you make that you solidified of what would happen when you arrived there at 9 p.m.?
What plan did I make? I'm sorry, could you repeat that question?
You just previously you testified that the plan was he was going to come out and you guys were going to go for a ride together. Just now you testified that he wanted the plan according to him was that you were going to come inside.
I'm thinking maybe he wanted me to come in. I don't know what was he thinking. But I can tell you that my plan was for him to come out. I don't know if he was...
Okay, so that was just your plan. That wasn't something that you guys discussed and agreed on?
No, not at all.
Okay, so you didn't discuss that when you had the phone call with him earlier then?
We just planned to just meet up with each other. That was the plan.
At 9 p.m.?
Yes. It could have been earlier, but he had to drop off his kids, and I respect that.
So, May 20th, 2022, you upon yourself just show up at Kenosha Police Department at 7 a.m. in the morning?
Correct.
No one had reached out to you to come provide... No. You went on your own accord?
Yes.
And do you remember that when you went to meet up at Kenosha Police Department that you had materials that you were going to give to the detective you spoke to?
Yes, my phone of the conversations I had with him and the conversations I had prior, which was the Facebook meets or Facebook dating app.
And those were screenshots, correct?
That date, no.
You didn't give any screenshots to the detective on May 20th, 2022?
Not that day, because they were going to meet with me again.
Okay, do you remember, strike that. I'm going to show you it's been marked as Defense Exhibit 235.
The defendant does go to jail every night. He is in custody. Sorry, I missed your question earlier, Big Sky. We're pretty relaxed here. As long as we're nice and civil to each other, there aren't a lot of chat rules.
Again, is Defense Exhibit 235.
I think, be nice is probably one of the big ones. Pickles, not politics. That's another one.
This is an email that you had sent to Detective Pereira on May 20th, 2020, correct?
Yes.
And around 8:26 a.m.
Correct.
And the subject is forward last text messages I had with Zario, correct? Mm-hmm. But his name is, that was a misspelling, correct?
Yes.
Okay. And in there you wrote, I'm forwarding over the extra information you asked for as an attachment to this email.
Yes.
And the attachments were screenshots.
Yes, and now I remember. Yes, those I sent those out. I remember those, yes.
Okay, so this is a forwarded email.
Mm-hmm. Yes.
Did you email yourself these screenshots prior?
Forwarded? Yes, I did. I kept those for my copy purposes. That's why.
So, at what time though? Did you provide that email that you had forwarded to law enforcement?
Your Honor, objective relevance of that. She testified she provided these screenshots as been identified. What does it matter if she forwarded them to herself first?
I sent them to him because that's what he asked for.
Not asking about you sending them to him. Sorry. Not asking if you sent them to him.
Mm-hmm.
No, let me finish.
Go ahead.
Okay, I sent them to him because he asked me for them. But I don't know if I sent them to myself or did I resend them to him because he must have said, I did not get them. I can go back and look at my email. I'm more than happy to do that.
So let's go through the screenshots. So this screenshot that you sent, and it's terrible quality. I'll try to zoom in. It might be that I have to hand you the actual exhibit. I'm going to hand you the actual exhibit just so you can see the text. But this is one where it starts about what are your plans tonight, and then basically would you be interested in meeting up? Is that an accurate depiction of what that text string is?
Yes.
Okay. And this screenshot was taken at 8:03 a.m., correct?
Correct.
So this screenshot then you had taken the day before?
What date is that?
So you emailed these as a forwarded email to Detective Carrera on May 20th, 2022.
Yes.
This is a screenshot that says the time that this screenshot was taken was at 8:03 a.m. You agree that's the time that's up on the top, correct?
On May 19th?
I'm asking you, what date did you take this screenshot?
I don't remember.
Did you take any screenshots when you were meeting with Detective Carrera?
Oh, I don't remember. No. I sent those I sent those the moment he asked me for them, but I don't remember the dates when I sent them.
Okay, so when I'm asking, you don't remember then when you took the screenshot?
I'm going to object to ask and answer. That's been asked 2 or 3 different ways at this point. She's indicated she does not remember when the screenshots were taken.
Her answer was that she doesn't remember when she sent them. She hasn't answered as to when she took them.
Did she say that she hadn't taken them?
Yes.
Or that she received them from someone else?
No, that she had taken them.
Well, how would it be a forward then?
Well, her testimony, Judge, was that she didn't remember when she had forwarded the email, but my understanding was that she had sent them to herself. She said she had sent herself her own copy. So, do you remember what date you took this screenshot on?
No, I don't.
I'm going to go to another screenshot that you sent. I might need to hand this to you if you can't read it. But this was a screenshot that was taken at 7:10 a.m., correct?
Yes. The time is on top.
Sorry?
The time is on top.
So at 7:10, were you already at Kenosha Police Department?
I'm just trying to figure out what date that I did send them, but I was over there around the time, 8 o'clock in the morning.
So if you were there around 8 a.m., we know it takes 37 minutes to get to your house, or get to Kenosha around. Did you take this screenshot early that morning or the day previous?
I think previous.
So then it would have been May 19th at 7:10 a.m.
I'm sorry, I don't know. I'm sorry, I don't know. I would have to go back and look at my phone again. I would have to reopen my phone.
That's fine. We'll just go to a different one.
She's not interested in the actual date.
With the
She's
timestamp,
just
correct?
tripping her up.
The time on that's 2:44 p.m., correct?
2:44.
At the top, the time that you took the screenshot.
Yes.
Because, I think this is common knowledge, but maybe perhaps not. When you take a screenshot on your phone,
Objection.
it's going to depict your whatever's on your phone, right? So your understanding is that if that time showed up, that would have been the time that the screenshot was taken on your cell phone.
Yes.
Okay. So you're with Detective Carrera in the early morning hours on May 20th, 2020. You'd agree that it would be physically impossible for you to have screenshot this text on that specific date, correct?
I'm going to object to physically impossible. I think it's a mischaracterization, and she said she was there in the early morning hours, which opens up the possibility of a lot of time that day. So I think it's a mischaracterization of what's been testified to.
I can rephrase and go through it a little in more detail. I'll go back to the time you sent the email.
Okay, we might need a timeline.
You sent the email at 8:26 a.m. on May 20th, 2020, correct?
Yes.
This screenshot is taken at 2:44 p.m., correct?
Yes.
So it would have had
Yes.
to have been taken on May 19th, 2020, correct?
Yes.
So knowing that now, does that help refresh your memory as to what date you took the other screenshots on?
Correct.
So this would have been taken at 7:10 a.m. on Monday, May 19th.
Yes.
And the other screenshots, the ones from 8:04 p.m. or 8:04 a.m. were also taken on May 19th, 2020, correct?
Correct.
Now, these screenshots that you sent Detective Carrera, they're not an entirety of the string of messages that you had with Mr. Gutierrez, correct?
The string of, you mean like the conversation I had with Gutierrez?
Yes.
That's the only thing I had.
So I'm going to give you Exhibit 235, and I want you to show me which attachment shows the text message that says that you're about to leave your house at 8:24 p.m.
It's a trap. We need that sound bite from Star Wars. I'd be willing to risk a copyright strike just to have that sound bite. Play it frequently. She's setting up a trap to get her. Here we go. I think Amber knows what's coming here. She's accusing her of making up the emails, screenshotting them, and forward the fake ones to law enforcement.
Or 8:20?
At 8:20, the one that I read to you earlier.
It's not here.
Sorry, can you say that louder?
It's not in this. It's not on these sheets.
So the attachments that you sent didn't include that message, correct?
The attachment that I sent to the detective. I sent him everything.
But you just said that you looked through this
I looked
exhibit,
through that one. It's not on there.
and it's not in there, correct?
Yes.
I'd ask to move Defense Exhibit 235 into evidence.
Objection?
I would ask that it be subject to cross or redirect against on it.
I would ask that
Can
something
it be
of a...
subject to redirect on it before it's officially moved into evidence?
Well...
Redirect on evidence?
See if it's subject to your recross.
Thank you.
Subject to recross of the witness.
Why didn't you just hand Detective Correa your phone to be able to look at the text messages?
I did.
And did you allow him to complete a Cellbrite download or a download of your cell phone?
He had mentioned there was going to be 2 officers coming to my home to speak with me. And those 2 officers, I offered my phone, and they said, we just want to see the text messages. And then they sent it to themselves.
The detectives took your phone and sent themselves the messages?
Yes.
Okay.
Or officers. I don't know if they're officers or detectives, but they reviewed my phone.
But they never took your phone completely to run any tests on it?
No.
Now, you said that you went to Kenosha Police Department the morning of May 20th, 2020, because you had seen a Facebook post.
Correct.
But you weren't friends with Mr. Gutierrez on Facebook.
Correct.
So what Facebook post did you see?
Since I didn't hear from him the 3 days that I was just kind of like, what's going on? I was like, maybe he's married or, he's not interested or what. But I saw on Facebook, it said in public, if you hear anything from Rosario Gutierrez, please contact Kenosha Police. So I'm thinking like, oh my God, what happened? So right away, I took the day off and I went straight I came here to Kenosha Police Station and I spoke with the detective and I explained to him not explained, but I asked him is there something that I'm missing? Is this guy, what's going on? And he started to ask me information like, how do you know Rosario? How did you meet him? And I explained to him I don't know too much about him. I just know a little bit of what we talked about. I gave him the whole conversation of what I had with Rosario last.
So, but back to the Facebook post.
Welcome, Detonator.
Who posted
Good
it?
to have you here.
I don't know.
Did you show detectives the Facebook post that you had seen?
No, I just seen it on Facebook and I just never.
At what time did you see it on Facebook?
Let's see. I seen it at nighttime, so it was must have been a Wednesday night. The 20th was a Thursday, right? Is that correct? It was the night before. I know it was the night before, and it was a nighttime. And I said, oh, geez, I got to go over there and see what's going on.
You got to go over there?
Like come to Kenosha and find out, like, is everything okay? Because I don't know. Like, I had the conversation last, and me working at the time period for the district attorney office, my job is important. I'm a mother, I don't know. I just thought the best thing to do was to give the officer my phone.
Okay, so May 20th was a Wednesday. I want to go back to the Facebook post. So May 19th was a Tuesday. So you're saying you saw that Facebook post the evening hours of May 19th, 2020?
Yes.
So not in the morning?
Not in the morning.
So not around 7 or 8 a.m.?
I know it was like a day, 2 days after. 2 days. Yeah, it must have been 2 days after, because I was so concerned, like, he never got back to me. I kept messaging him.
Wait, I'm just asking about this Facebook post, so I'm going to keep it to that.
Yes.
So it wasn't around 2 p.m. mid-afternoon either. It's later than that. You see this post.
Correct.
So I want to go back now to May 17th, 2020. You thought you used Google Maps on that day, but now after seeing your screenshot, you know you used Apple Maps on May 17th, 2020.
Correct.
And when you spoke with officers, I believe it was on the 22nd, you spoke to someone other than Detective Correa, correct?
Yes.
And you had told those officers that you were outside of Mr. Gutierrez's apartment building, right?
Yes.
And when you got there, you could see the numbers on the apartment building, right?
Yes. No, it was kind of dark. I'm just following by what the maps was telling me, so it was kind of dark.
I'm going to show you what's been marked as Defense Exhibit 58.
They have not established that the lights were turned on or even worked over the numbers, over the address on this house, but we'll see if an objection gets this through or gets this blocked.
Does this look like the front of the apartment building that you were waiting at?
I'm going to object.
There's an
With
objection.
the apartments, they're essentially all identical, so in terms of being able to, if you asked about the address specifically, if you saw that, I think that's appropriate, but all of the apartment complexes are identical, so whether she's in front of this one or one that looks identical would have to be determined by the address, not necessarily.
You're testifying right now. You can cover this on your redirect. Although the point may be a good one, and so.
She was there, Judge.
Understand?
They all look the same. They really do look the same. The same door, the color of the door, from what I'm seeing right now.
The taped door looks
No. Just the color of the door.
Okay, but there's numbers on top of the door, correct? Can you read the numbers that are...
It says here 3709.
Okay, thank you. So Apple Maps could have taken you to the correct address, right?
Your Honor, I'm going to object. She testified to where it took her. Whether or not it could have taken her to the right address, I think is irrelevant. She's testified under oath where it took her.
Judge, on direct, the state said, oh, you took Google Maps, and Google Maps took you here. We now have that she took Apple Maps on May 17th, 2020. Completely different maps. So
No.
I'm able to go into this.
Well, I just want to make sure that it's the defendant who is giving the testimony, and not the attorneys.
Well, she's allowed to lead on cross.
Haven't actually been produced in testimony. So again, I'll repeat, you can cover on recross.
Can you need me to repeat the question?
Yes,
With
please.
respect to the questions by the attorneys, occasionally lawyers, and we're all guilty of it, will form questions in such a way that assumes facts and asks the witness to affirm them. And sometimes the witness takes a different course and doesn't directly respond to that. Keep in mind that if the witness does not affirm what the question presupposes, then it's not reflective of the witness's answer. Any question about that? Okay.
So it's possible that on May 17th, 2020, you were taken to 3709 15th Street.
You're asking, she was taken?
Sure,
Directed, is that what you mean?
Sure, I'll rephrase. it's possible that Apple Maps would have taken you to 3709, that building, on May 17th, 2020.
But it didn't guide me there. It guided me a whole different building. That's what I'm realizing.
But you said okay, so later in March of, what was that, 2022, correct?
Yes.
2 years later, you used Google Maps to return to the Wood Creek apartment complex.
Correct.
And when you used Google Maps, it took you to the building you pointed out during direct.
Correct.
But they all look the same.
Yes.
So it's possible that when you used Apple Maps directed you to the other building, the actual building.
The actual building. It never sent me to an actual building.
But, okay, so March of 2022, you actually had gone back to that location before March 2022, correct?
With the DA and the detectives.
No, I want to talk about, the time that you went to the scene
There it's in.
only with the district attorneys.
Well, with the people from the district attorney's office, is that what you mean?
People from the district attorney's office. You remember that meeting?
Yes.
And who were the people of the district attorney's office that you met with?
The district attorney, I'm sorry, I forgot your name. I'm so sorry.
Ms. Kazarian?
I'm sorry, how do you say your name?
Jessica.
Yes, Jessica. And it's another gentleman. I'm sorry, I can't
Looks
remember
like
his
Steve
name.
Martin.
Can you describe what he looked like?
He's a very tall gentleman.
I'll stipulate it's DA McGravely.
The district attorney?
Yes.
Yeah, okay.
And how did that meeting come about?
He called me that day and he's like, "Where are you?" And I'm like, "I'm at the building where it's."
Sorry.
I'm going to she's asked a question. She's answering the question. I believe it should be fully answered before we move on to the next question.
I'm gonna withdraw that question and rephrase it.
Well, you can't interrupt the witness. Did you understand the question?
Oh my God, I'm so sorry. Can you ask me that question again, or?
Sure.
All right, go ahead.
So prior to you meeting with District Attorney Mike Gravely and Jessica Piscaric, how did you know to go to that location?
How do I know to get to that location? Because the DA gave me the address and said, "I will meet you to that location so you can explain more detail. Where exactly were you parked?" I said, "Okay."
So did you call the district attorney or did the district attorney call you?
They called me.
And do you remember the district attorney telling you that there's something off with the timeline?
Just the map. It was kind of like the Google Maps, and we were just kind of figuring out the map. Why did my phone directed me again to the same location where it sent me the first time?
And Attorney Gravely had asked you to do that, correct?
I'm going to object it to ask her to do what?
Asked you to do that? The question was asked you to do that?
It's vague.
It was a follow-up to her answer just now about comparing the map to your phones to Google Maps. Attorney Gravely asked you to do that, correct?
Just to kind of review my phone, and I showed him my phone. This is where my phone directed me to to that other building.
But he didn't ask you to pull up it on Apple Maps, correct?
No, not that I remember. No.
And that was approximately 2 years after you had been to Wood Creek Apartments in May of 2020, right?
No, that was like a year ago, 2 years ago. Like a year ago. No, it was a year ago after I met up with him. It was a year ago.
So back now to the Apple Maps. Is it possible that where you were when you met with the district attorney is different than where you were on May 17th, 2020?
No, it was the same location.
How do you know it was the same location?
Because he called me and said, "Where are you?" And I said, "I'm right here where I was waiting for Rosario." He said, "This is not the building. The building's over here." And I said, "Well, you can see for yourself." And I showed it to him.
But you previously testified that all the buildings looked exactly the same.
Yes, they all look the same.
So how do you know you were at a different building?
Because the phone had a little red dot that pointed to me that was the building.
But you were using Google Maps.
Here, no, I'm going to object. Asked and answered. I think now we're on, time 4.
Well, the organization leaves something to be desired. Let me rephrase your question. Let's take it from there. As to what event she's talking about and what the source of her information was and the impression that she formed as to where she physically was.
Did you look at the apartment building numbers at any point?
I did not really pay attention, only because I was only going by what the map was telling me.
Okay, so then...
Nobody can hear.
Yeah, I don't know what's going on. It's been a couple of months that the sound has been worse and worse. And it's not your fault, ma'am.
Sorry.
Unless that green light isn't lit, because then
It's lit.
Press the bar in front. Yeah? No, I don't know. I'm having terrible trouble with that, hearing from that microphone.
Can you hear me now? To me, all the buildings, they look the same. The moment you drive in, they all look the same.
But when you met with the DA's office, you used a different map application.
Correct. The Google.
So it's possible where you were on that day was different than where you were directed previously.
Your Honor, I'm going to object. This has been asked and answered multiple times. She indicated she went to the same place she had been directed before and was surprised that we weren't there.
We could cover it on record.
I'm not sure. All I can say is, for some reason, God guided me that way, and I don't know why. I arrived at that same building 2 times. I arrived at the same building two times. Both maps, both times I put it on there. If I put it on there right now, it'll probably guide me there again. I don't know.
So, but you didn't use Apple Maps when you met with the DA's office, correct?
When I went to the DA office, did I use Apple Maps? Is that what you're asking me?
When you went to the Wood Creek Apartments, when you met the district attorneys there, you did not use Apple Maps.
No, I used Google.
So you're saying all the buildings look the same. You used a different application the second time to get there. So all I'm asking is it possible that on May 17th, 2020, you were actually in front of 3709 15th Street?
Your Honor, I'm going to object. She's indicated she didn't really look at the numbers, and she said where she was on both dates. So we have asked this question multiple times. She's answered it multiple times, and we just keep going in circles trying to get a different result.
Judge, she hasn't answered the question. Her answer to the question each time is she used Google Maps and everything looks the same. So I'm trying to break that down, and we know she testified earlier that she used Apple Maps on May 17th, 2020, and she's not been able to provide an answer as to how she knows definitively that while using a different application, she arrived at the location that she was directed to Apple Maps on May 17th, 2020. I'm simply trying to get an answer to that.
I think the subject has been extensively covered, and it may be that the clarity that you're seeking isn't there.
You didn't read any of, on May 17th, 2020, you didn't look at the apartment building number.
On May when?
17th, 2000?
No, because it was dark and it was rainy.
You said you had your lights on?
Yes, but my vehicle is not that. It was an old Toyota that I had. It's not even that bright, so I couldn't even see myself. That's why I said I wait for him to come out. I'm not gonna.
But you said that you pulled up, right? So you said you pulled your car up. That you were back by the dumpster, correct?
Correct.
And that you pulled your car up to a closer up spot.
Correct.
Which would be approximately 10 feet from the building, correct?
Correct.
With your lights on.
Correct.
And you're saying you didn't look and read what you read today, which was 3709 apartment building number. You didn't read it.
No, I didn't. I was more worried for him to even come out. I was nervous. I wanted to get to know him. All I remember seeing is a heavy-set woman coming down the stairs. There's light in the hallway, and some young guy was going down the stairs, and then he went back up. I don't know. I didn't want to get to the door and ring the doorbell or anything because I wasn't sure if it's one of those apartments that they have to buzz you in. I'm not going to stand in the rain.
So now you just said that you observed we'll talk about what you observed now. You said you observed a heavier set woman going up and down the stairs?
Yeah.
Do you remember on May 22nd, 2020 saying that you saw a Hispanic male going up and down the stairs?
It's like a Hispanic male, yes.
And that you actually saw a heavier set black female woman with a bag enter the apartment building?
Correct.
So you didn't see are you mistaken that you saw the black female woman going up and down the steps that you had just seen her go in?
Yes.
Right. And so you said that you could see what was going on in the apartment building.
Correct.
So you were close enough to observe what was going on in the apartment building.
Yes.
And do you remember being asked if you saw any vehicles around the area when you were there on May 17th, 2020?
I saw like another Toyota, like a blue Toyota, drive past me with tinted windows, but didn't really pay attention to that.
Do you remember saying you saw a white four-door vehicle as well?
There's a lot of vehicles there, so I didn't really pay attention to other vehicles around me. Everybody's vehicle was parked.
If I was to show you wrote a statement in this case, correct?
Yes.
If I was to show you that, would that help refresh your recollection?
Yes.
The silence. Oh, it was welcome for a minute. Let's listen to the Darrell Brooks raps. This is rough. I needed to move on, but I wanted to reach the conclusion here. Steve Martin got kicked out of court for this witness because he went and interviewed her on his own with actually the lady who's the defense lady who's doing the cross or doing the direct. Amber.
I thought you were talking. Excuse me.
You said excuse me? Steve Martin got the boot just for this witness.
Did that help refresh your memory?
Yes.
Okay. So, do you remember telling officers that you saw a white four-door vehicle as well?
Yes.
Okay. The further off the rails this testimony goes with this witness, the more the chance of the DA getting called as a witness. I think it's going to happen now.
So, I want to go back to your screenshots. Defense Exhibit 235.
That's Sadie right there. She's the girlfriend.
Do you remember sending this screenshot with the timestamps of when you sent your message to Detective Correa?
Do I remember when I sent this timestamp?
This is one of the screenshots you sent to the detective, correct?
Yes.
Okay, and the times that are next to your messages would have been the time that you sent those messages.
Well, which incident of sending?
When she sent the actual text messages.
But you're inquiring about transmission to Detective Correa?
No, when she sent those.
When they originally sent them to
Correct.
herself?
Yes.
Your question was
when
unclear.
It's not off the table.
When you send a text message on an iPhone, you can swipe right to see the time that you personally sent that text message.
But the question inquired when, I think, what was the time at which you sent it? And I was inquiring whether you were talking about sent a copy to yourself, or whether it was the time when she transmitted it to Detective Correa, which was the subject of your sentence.
No.
Rephrase your question.
Sure. Can you explain what the timestamps next to your text messages indicate?
Are you talking about the delivered part?
Yeah.
Well, it says that I left at 10:18. Is that what you're?
No, but so you see that there's a bunch of different times. 9:37 p.m. We'll start with that one. 9:37 p.m. You see that time?
Yes.
That was the time that you sent the text message 5 minutes away to Mr. Gutierrez's phone, correct?
Okay. Yes.
And then the same for the 9:43, the 9:44, 9:52, 10:08, 10:18.
Okay. Yes.
So you got there according to this text message at 9:43.
Okay.
43 minutes after you were supposed to be there.
Yes.
And you then leave at 10:18. According to this.
Yes.
So You just started talking to a guy and you waited around for over 30 minutes? Why?
Yes. Well, just while I was waiting for him, I was on my Facebook, so I was just kind of like waiting. I don't know if he was in the shower. I don't know if he was getting ready. But like I said, I waited for him because I thought he was a very good guy. A guy that really expresses himself a lot about his job, his mother, and his kids. To me, that really says a lot about a person. He said he's been single for a very long time, and I said, well, so was I. So, I mean, what much can I say? I wanted to wait for this person.
Even though you were scared and nervous, you wanted to wait more than 30 minutes for someone to respond that you never met before.
Well, I've been single a very, very long time. I've been divorced since 2014. So meeting somebody was very nervous. For me, I was nervous. I was very nervous.
You also called Mr. Gutierrez that night as well, correct?
I was what?
Called Mr. Gutierrez?
I did.
Multiple times?
Yes, and he did not answer. That's when I thought, well, maybe he's married. And I said, oh, it's time for me to go.
And then on direct, do you remember being asked the question by the state if at this time in your life you had anyone that would be jealous of you going to meet a man? Do you remember that question?
I'm sorry, can you say that again?
Do you remember being asked on direct the question that at this time, around May 17th, 2020, did you have anyone in your life that would have been jealous?
Yes.
And you remember saying no?
No.
But you did have an ex that was extremely jealous, correct?
My ex-husband? No, he already did his life. So
he did his life.
What else can that be?
You had never, previous to this date, indicated that an individual that you had dated had, even though they were in custody, would still act jealous if you were talking to other men and would accuse you of talking to other men.
Object to the relevance of this as well as the vagueness.
The state,
yes,
opened the door.
Well, it needs, for certain, it needs to be clarified.
Sure.
Rephrase your question.
Do you remember having an ex-partner who you were relatively scared of?
Yes.
And that person, you had thought at points, even if he was in custody, that he was keeping track of you, correct?
Yeah, but that's... I mean, I don't know what you're asking me. I'm sorry.
He was a jealous ex?
Yes.
No further questions.
Any redirect?
Yeah, there's quite a few redirected. Just on that last point, we'll start there. Did that person have any idea you were coming down to Kenosha to meet Mr. Gutierrez Jr.?
No.
Can you get a mic closer to you? Sure.
That person remarried, from my understanding. I have more children, so I don't know. Where is that question going?
How, I guess I'll follow up to that. How many years ago was this jealous ex in your life?
2017, 18?
So several years prior to 2020?
Correct.
You had indicated on cross that you had seen a Facebook post in the evening hours of May 19th regarding Mr. Gutierrez Jr. Accurate?
Yes.
About him being missing?
Yes.
And upon hearing that information, what about that made you decide you needed to come down to tell what you knew about your supposed meetup with him the night of the 17th?
What made me come here?
Yes.
I'm a mother, and if anything happened to my son's 20 years old. If something happened to my son, I would need answers. And I feel like I put myself in his mom's shoes. That really hurt me. And I had to say something, step up and say something. If I have some clues or answers, I have to give this to the police. Why? Because it's the right thing to do.
And so you drove down then in the early morning hours of the 20th directly to the police station at roughly 7 a.m.?
Correct.
And you met with Detective Correa?
Correct.
And when you were meeting with Detective Correa, were you trying to show him some of these messages that are on your phone?
Yes.
And so when you're with him, are you taking some of these screenshots to kind of show him what you're talking about?
Yes. I was showing him everything.
I'm going to object to leading and have that be struck from the record.
The objection does sound leading to me.
What information did you want to provide to law enforcement on the 20th regarding your interactions with Mr. Gutierrez?
Everything. Messages from Facebook to the times that I talked to him, everything. I told him where I worked. I told him everything because to me it's like being forward and coming clean of who I am. There's nothing to really hide about it.
And subsequent to meeting with Detective Correa, did he make any requests of you in terms of getting those messages to him?
I'm sorry, can you say that again?
Yeah, subsequent to actually meeting with Detective Correa in person, did he request that you email those messages to him?
Yes.
And so after leaving the Kenosha Police Department, did you then take the screenshots you sent to Detective Correa?
Yes.
And did you have more email conversations where he asked you follow-up questions regarding those messages?
Yes.
And was one of those specifically about timestamps of when messages were sent?
What do you mean, like from me and Rosario, or timestamp from?
I'll rephrase. So there was some talk on Cross about some of the screenshots being at 7:10 a.m. Do you remember that? 7:10 in the morning?
I know it was in the morning, but I don't remember exactly what time.
And then there were some that the screenshots seemingly implied they were about 8:03 a.m.?
Yes.
And then some later ones that came at 2:44 p.m.?
Yes.
In the original email to Detective Correa, which was shown to you with the date and time of May 20th at 8:26 a.m., did that email include the messages, the screenshots that you had from 7:10 and 8:03 a.m. that day?
Yes.
And subsequent to that, were there conversations via email with Detective Correa regarding some follow-up questions he had regarding your messages?
Ease up, everybody.
By email, no.
We're not on trial.
Did you
And we're not
request
these
further
attorneys.
screenshots of your messages, specifically with timestamps?
Yes.
So, where are
We're trying to catch up. I'm not sure if we're going to get all the way caught up by the end of today. We're trying to get done with... we might start like half an hour early tomorrow to try to get caught up. But we just want to finish what's happening. I want to get live, hopefully by tomorrow morning. I would never remember the answers to these, Jen Jane, dear girl. I'd be like, can I refresh my recollection?
Handing you what's been previously marked as Defense 235. Can you just identify that this is a screenshot from 7:10 a.m. with messages starting 5 minutes away?
Yes.
And then the following page from Defense's 235, is that a screenshot of those same exact messages, but from 2:44 p.m. with the timestamps next to them?
Yes.
And after you had sent the original messages from 7:10 or 8:03, did Detective Correa ask you for ones with the actual time and date stamp of all of the messages being sent, not just the top one?
He asked me for all the messages, so I sent him everything that I had.
So, back to Defense Exhibit 235, the 7:10 screenshot doesn't have all the times next to it. Is that accurate?
Yes.
Okay. And so, you have an iPhone, is that true?
Correct.
And so, in your familiarity with iPhones, when messages are sent in quick succession, is usually the timestamp only at the top of the message that are sent quickly? Or in a short succession, I guess I should say?
What do you mean by that?
So if you would look at messages on your phone, normally without doing anything else, would it appear the way it does at 7:10 a.m. where it just simply starts your messages at 9:37?
Objection leading.
Yes, it is.
Is this the normal way your phone would appear if you just took a screenshot?
Yes.
What extra step, if any, do you have to take on an iPhone to get additional times for date stamps next to it?
You have to hit the screen, push back. It's like extra work, I would say. So you would grab your phone, push back, and then snap it.
So you would have to take additional steps to do that?
Correct.
And so if you had originally sent
Swipe your finger.
the screenshots to
That's
Detective
hard.
Correa, would it have been a request from him or somebody else for you to do that extra step?
What do you mean? Like if it would be from him,
When you took the initial ones at 7:10 and 8:03 a.m., you didn't take that extra step?
No, I didn't.
Subsequent to that, you took that extra step?
Right.
Was that a request that law enforcement made of you to get the exact times your messages were
Yes.
sent to?
He just said, make sure you get the times. And I must have sent that one first and then just kind of
start working through the other ones.
So there were multiple communications and sending of messages to Detective Correa as part of this case?
Right, yes.
Now, you were asked when these screenshots would have then been taken and sent. And so in looking at Defense Exhibit 235, this first email you have with Detective Correa, which you testified to, comes through at what time?
8:26
a.m. on the 20th? So if you had to take additional steps to do that extra piece for 2:44 p.m., would that message have to have come through to the detective after May 20th at 8:26 a.m.?
Yes.
I'm going to show you that map again of the Wood Creek Apartments.
The mic they just turned on needs to be just destroyed. Thank you.
The night of May 17th, which building specifically did your whatever map program you used take you to where you thought you'd be meeting Mr. Gutierrez Jr.? Which building on there? If you'd like to get an approach.
I'm going to object as far as it's kind of argumentative and testimonial in that this witness at length on cross was not able to definitively say which building she was at on May 17th, 2020.
Maybe it was the way you asked the question.
Oh.
I don't know. I'm not suggesting that's the correct answer. I'm just saying I don't know. The witness can speak for herself. You can ask on recross.
So on May 17th, that's the building your GPS took you to?
Yeah.
And when you testified on cross regarding meeting up with myself and District Attorney Gravely, what building did your GPS take you to on that day? So that same building? And you'd indicated that there was a little bit of surprise from the District Attorney's office in terms of the fact that that was the building you were at?
Objection calls for hearsay and speculation.
Your Honor, they opened the door to it and she testified to it.
Well, I think
I'll withdraw my objection.
I'll withdraw the question.
Whoa.
So on both May 17th and in March, when you met with the District Attorney's office, that's the same building that you were taken to?
keep using the term taken to. Directed to, maybe?
She's also leading judge.
Well, she's just repeating what she already said.
Then asked and answered.
I'll move on.
Bless you.
Wow. That's the lead investigator leaning over, giving her a little tip. Because the DA is not there to help her. Sadie has not testified yet. Do you anticipate she will?
Thank you.
Sometime?
Any question?
Yes. Back to the GPS or the map application that you were using. You were using a different map application on May 17th versus the time that you met with the district attorney's office, correct?
Yes.
And when you met with the district attorney's office, when you met with Mike Gravely, where did he meet you? If you could point out on the map, where did he meet you when you met with him?
Let's see where it is.
Here, and I believe he was somewhere else, and he was asking me, where are you? And I told him I'm right at the same location where I was at from the date that I was supposed to meet Rosalio, and walking from this angle, and I was already parked here waiting for him.
So previously you told law enforcement that you were in front of Mr. Gutierrez's apartment, correct?
Yes.
And then it's only after you met with the district attorney, Michael Gravely, that you are now saying you were in a different location.
There was 3 different...
It's a yes or no answer.
No. I don't allow witnesses, lawyers to restrict witnesses like that. Go ahead.
Seriously?
There was 3 different times I moved. When I arrived, in the beginning I said...
Which date?
I'm sorry?
Which date?
May 17th,
Okay, go ahead.
2020, I arrived and I parked over here, and I waited for a couple of minutes, and then I parked by the dumpsters.
This is non-responsive to my question.
Go ahead with your answer.
And after I waited a few minutes, I parked right in front of the building.
I'm going to ask you the same question again. You can sit down. You previously said May 17th, on May 20th and May 22nd, when you talked to law enforcement, when you talked to the detectives, you told them you were in front of Mr. Gutierrez's apartment. You then, when meeting with the district attorney, Mike Gravely, said you were in front of a different building, correct?
That's the only building that I was at when I was supposed to meet Rosalio. I don't know where does he really live. I know that's the building that old map's guiding me to.
Well, when he texted you, he gave you his apartment building number, right? He gave you his apartment number, 1B, correct? And when you had that information, you then told law enforcement you were at his apartment.
I just pointed out the building that I'm thinking that's where he lived.
State had asked you about the meeting with the district attorney's office just now.
Jury is here, yes.
You had said that attorney Mike Gravely had called you. Were you expecting that phone call?
From the DA?
Correct.
No, I was looking around like, where is he? And I was looking for the other lady that was with him. And I was standing in that same building that I just pointed out, and I didn't see them. So I was just waiting and waiting. Finally, they called me and they said, where are you? I said, I'm right in front of the building.
So I'm sorry. The phone call you received from attorney Gravely asking you to meet him at the scene.
Yes.
Were you expecting that phone call?
What phone call? From him?
Yes.
No, I was expecting to meet him at that same building.
But, okay, you keep saying you're expecting to meet him at that building. But prior to your expectations of meeting him at that building, were you expecting the first phone call where he called you to tell you to meet him at Wood Creek Apartments?
No, I wasn't expecting that because we were here and we met up here at the DA office. We talked about it and he says, we're going to meet you over there and I'll see you shortly. I said, okay, then I'm going to head over there right now.
So prior to you going to the scene of the crime, you had met with attorney Gravely at his office?
Yes.
And what did you talk about in that meeting?
To basically that I'm going to be subpoenaed and that I have to come in court and testify. And that's it.
And
as a witness. And I asked him questions like, well, did we hear anything about Rosalio? What happened? What's going on? Nothing. He didn't say nothing. He just said be prepared. Well, it was very briefly. We weren't here very long. We just met up here, just told me we're going to go back to the scene and you're going to explain to me, us, the lady who was there, and you're going to tell us what exactly, where were you parked?
So he told you that he needed you to tell him where you were?
Yes.
Because something wasn't adding up, correct?
He didn't say that, nothing. He didn't say something wasn't adding up. He just said we're just going to go back and you can explain a little more detailed where were you parked.
But he did tell you that your timeline didn't add up to the evidence.
No, he didn't say it didn't add up. He just said, we just need to know what time, how long were you at that, where were you parked exactly.
But he told you there was an issue with your timeline.
I'm going to object to ask and answer. She's used even timeline multiple times, and she said that's not what he said to her.
This shall exhaust the line of inquiry. Go ahead. Did you understand the question?
Yes. And he didn't say something that did not add up. He just said, we just need to go there and kind of give us a little detailed information. Where were you parked?
That was my second to last question. My last question was, there was some issue that he had with the timeline, and that's why he then wanted to take you to the scene.
Well, she said he had not said that. Now your question seems to be inquiring what was in Mr. Gravely's mind, which would be speculation for this witness.
I'll move on. So who then called you to meet? How did you know to come to the district attorney's office to meet prior to you going to the scene?
One of the ladies, she works at the DA office. I'm sorry. Is
Judge, we can't hear.
is she an advocate, or I'm not sure. Was her name Heather?
Sorry, are you asking the state official?
I don't know. I'm trying to remember one of the ladies that called me to inform me to meet with the DA.
So it wasn't, you hadn't called the district attorney's office?
No, they called me to tell me to come to the office, and we were going to discuss a little bit on what was going to happen. I was going to get subpoenaed, and I was going to, come to a court date. And that's it.
Was it Attorney Gravely's idea to take you to the scene of the crime?
I don't know if it was his idea or not. I just was told to go to the scene.
But it wasn't your idea?
No.
You didn't offer to go there?
No.
And then when you were at the scene with Attorney Gravely,
nothing. He asked me, where were you parked? How long were you here? What time did you move your vehicle? Like those 3 times that I moved my vehicle, where was I parked? And he asked me in the beginning, like, where are you? And I said, I'm at the location, at that building. He says, are you sure? And I said, yes, I'm at this building. This is where Google and Apple guided me to go, and I was told that that's not the building.
Mike, Attorney Gravely told you that's not the building.
That was it.
Correct?
My understanding, that's how I took it. That's not the building.
So, just if you can answer the question directly.
What do you mean?
No, that's my question. Sorry. You're fine. The district attorney told you when you were there, that's not Mr. Gutierrez's apartment.
Right, yes.
And then, did he take you to Mr. Gutierrez's apartment?
No.
So after you take Google Maps to that location at the request of Attorney Gravely, Attorney Gravely says, that's not it, and that was everything?
That's it.
Nothing further.
Any question?
Two questions. When you gave your first statement to law enforcement back on May 20th, it was memorialized on the 22nd, and you said you were in front of Mr. Gutierrez's apartment, did you believe that the apartment you pointed out to us twice was Mr. Gutierrez's apartment?
Yes.
And knowing what you know today, do you have any guess which of those buildings on there is actually his real apartment?
I don't know.
I have no further questions.
Any questions?
No.
Thank you. You may step down. Thank you. Let's break, folks. And let me ask that you return at 1:30. And please don't read, watch, or listen to any account of the trial, and don't discuss the case with anyone, even members of your household or fellow jurors.
We're going to skip ahead here because we're going to try to catch up as much as we can. We want to get with this as close to the end as possible. Let's see, so what's my time? About 3:58. Skipping ahead. We're still 4 hours behind. That's bad. That's really bad. 3:49. It's a 20-minute break, right? I don't want to use the slider button or else I'm going to completely lose where I'm at. 5, 4, 3, 2, 1, 0. Any second now. Now we're only 3.5 hours behind. That's good. Look how much time we're saving. Okay, there's the tech guy that comes in who's working on the mics. Hopefully it gets better after this. See his hat in there. We're only 3 hours and 15 minutes behind. Here, I'll let you look at this while I'm skipping ahead here. Auxiliary 2. That was horrible. That was painful. They hadn't taken lunch yet in the video yet. This is Golden Mom. I think they're taking lunch right here. This is their lunch. Because now we're less than 3 hours. Less than 3 hours till live. Okay, 2:40. There we go. Okay, here we go. Right there. And
everybody here, I guess so. Go ahead.
Judge Eileen Knoll has 0 pride. Eileen Knoll has 0 priors. Neridia Macias had no priors. I don't think we did that before she testified. Michael Campbell has no priors. Brandon Hendrickson has a 2010 disorderly conduct. We are suggesting that's outside the 10-year rule, which would at least be one consideration from the court, knowing it's a disorderly conduct. My understanding is defense wishes to make an argument regarding that. Do you want to do that before I go on?
Well, it's not a 10-year rule in Wisconsin. Wisconsin is explicitly, well, not explicitly, but has, by non-adoption, has rejected that 10-year bright line. But it's a DC, more than 10 years old.
It's a DC from 13 years ago, and I did not mean to imply that we had a mandatory rule. I just indicated perhaps was a factor.
What's up from the defense?
Judge, this witness is an individual that had accompanied Mr. Campbell to Mr. Anderson's home. I think that given his involvement in this case, that his prior conviction, that the fact that he has a prior conviction should be heard by the jury.
Do we know anything about the nature of the DC?
No, but I'm only aware that it's supposed to go to credibility. I'm not aware that the court would typically make a decision about impeachment based on a prior for any other reason other than credibility.
Well, I do agree with you there.
Okay.
And in this situation, there is some evidence that Mr. Hendrickson had a gun with him at the time that he did go to Mr. Anderson's home. It's my understanding that he will probably testify contrary to that. And I think it's important that his conviction, the fact that he has a conviction, obviously we won't go into what it is, that should be heard by the jury, especially since we don't know what he's going to say as far as why he accompanied Mr. Anderson, what he had, and what he was planning on doing had he confronted Mr. Anderson.
I'm unaware of any evidence that he had a gun. If counsel is presenting evidence he had a gun or wishes to impeach with evidence he had a gun, I'd certainly ask them to share that with the court, but I'm unaware of any evidence he had a gun and do not believe that's relevant in terms of this analysis.
Well, first off, I do agree with the point made by Mr. Gravely. This is strictly for credibility, and the role of the defendant with respect to any events would ordinarily not be a factor in the determination about credibility. And of course, this is all dependent upon whether he testifies anyway. In addition, I don't know the fact that he may or may not have had a firearm. If that is shown or suggested, I don't know whether carrying of a firearm would have been lawful. I think that the best approach is look at it strictly from its usage for credibility purposes, and a 10-year-old DC without intervening events, criminal events since then, I would ordinarily not admit. So, unless you have something else, I'm going to say that's not grounds for impeachment.
Nothing further.
Okay.
Okay, there's a woman named Erica Saylor, S-A-Y-L-O-R, who we intend to call as a witness in this case. She has a 2005 bail jumping conviction, and so that would be 18 years from now, 15 years from the date of this offense. And we, again, do not believe that should be counted, but counsel has indicated they wish to make argument on that as well. I'm aware of the circumstances of that bail jumping if the court wishes me to share those.
The defense is withdrawing the prior objection to including that.
The request that it be included is withdrawn. Okay.
Correct.
Then that settles that.
And then we have a witness, Marquand Washington, and the parties, I believe, have come to an agreement that he has 6 prior convictions.
Is he in agreement with that?
Apparently everyone's been arrested in this state. What's up with this?
CCAP of his 6 priors. We have not shared that with him specifically, but we're aware from reviewing CCAP they're all Racine County convictions.
Don't stop
so
counting, Ivan. You're good. Keep going, running your.
Well, the critical point is you can't come up here without having advance notice of.
I will certainly consult him and let him know.
Impeachable number, and of course the question should be phrased for a purist like me. Some of my colleagues are all right with having witnesses.
Judge, is your microphone on? I have a tough time hearing.
Oh, it is. Yeah, I don't, but anyway, I go to these conferences and some of my colleagues think it's quite all right to have a person who's got 25 priors to get instructed that there's only 3, and after having taken an oath to tell the truth, testify to that. I don't believe that. So it's all in how the question gets asked, and this is where leading questions are so good. Whatever your number is, if you're both agreed on it, and it is indeed sustained by his record, just ask him, you have 6 prior convictions. No? And
I will.
Yeah, and you can tell him if he answers that way, he won't have to relive the sins of his past life.
I will instruct him accordingly. So those are the priors that we wanted to cover at this point, and so I believe we're ready if the court is ready.
I'm ready.
I'm ready.
Ready?
One moment, Judge. Judge, I don't know who the state's calling next, but if it is Michael Campbell, then there is something that the defense wants to be heard on.
It's not. It's not? Okay.
But
if it's going to be soon, let's do it now before we bring the jury down and then have to send them out again. So what's going on? Is he going to be hearing? Or
He'll be in the first 3 witnesses this afternoon?
Huh?
He'll be in the first 3 witnesses this afternoon, Your Honor.
What's up with Mr. Campbell?
Sure. The court's well aware that Mr. Campbell was the target of a Denny motion filed by the defense.
Correct.
So we do anticipate asking him some questions as it relates to his involvement in this case. And we just wanted to make a preview of that. So if the state would have any objection or try to assert that we're attempting to introduce Denny evidence as it relates to Mr. Campbell, that we can be sure that the introduction of that evidence is solely for the purpose of establishing a fact of the events that occurred around May 17th to May 19th, 2020, and that anything that would be offered that could imply that any sort of involvement is just being offered for further questioning with detectives about the police investigation.
So far, I don't know what we're talking about.
So specifically, what we intend on diving into with Mr. Campbell are the following. The first would be him being present at Mr. Gutierrez's apartment on May 17th, 2020. That he had gone to Mr. Anderson's home with his friend, that he had interjected himself in the investigation, and that he had items in a van that he had allegedly taken to Pheasant Run Security Landfill, and also his whereabouts on May 18th, 2020.
So we object to any...
All of which wasn't followed up on.
So we object to anything about items in a van on the 18th, but certainly proximity to the apartment appears to me to be something that would be appropriately asked. Where he was on the 18th, I guess that's fine if the court finds that a relevant question in the context of everything else that's going on. I guess so. I guess I'd ask the court to see where we're at when that comes up, but I appreciate being on notice about it. What was the last one? I apologize. 18th?
The 18th.
What was in the van?
What was in the van? Pheasant Run Hill Landfill. No, what was in the van? I don't know. I didn't say that.
Oh, what was in?
Pheasant Run Security Landfill.
Security?
Landfill. That's just the actual full name of it. Most people were... Yeah, I don't know why, but that's what Waste Management tells me.
Yeah, what he dumped at a landfill, unless there is some specific additional information that wasn't shared at Denny, in the Denny motion, I think is irrelevant. Again, I would suggest to the court that let's see what happens about his whereabouts on the 18th, if that would be relevant. We know that I think his being at the home on the 17th in that early morning hour time period is an acceptable question, and I think what he did on the 19th in terms of going to the scene and also going to the house of the defendant is relevant.
Okay. So, I don't have to rule on anything right now.
No.
But we know what we're up against. All
Yes,
right.
we do.
Anything else right now?
Thank you, Amber, for this.
Not
Evidence
from
of a motive of one other than the defendant to commit the crime can be excluded when there's no proof directly connecting that person with the offense charged. There was actually a motion for mistrial
Thank you.
earlier in this case. We covered it yesterday, very early on, when I think it was actually during the opening statements of the defense, where they basically said, I think Sadie did it, and sort of threw her under the bus. They managed to get past that. They're going to bring in a special witness just to address that issue, and they've agreed to move on and withdraw the motion for mistrial. Let's see. He's being nice to opposing counsel, having no idea what she's going to examine him on yet. The Denny is actually, they're referring to State versus Denny, which is a Supreme Court of Wisconsin case. back from 1984, State v. Denny. But yeah, it's the blame somebody else who's not related to the case. Has no evidence that they did it. You can't just stand up there and say it was someone else. It was this person right there. He did it. Yeah, let's see how this goes. The defendant has a pretty nice looking tie on.
Good afternoon, everyone. And let's continue with the state's case.
State called Officer Sean Giovannoni to the stand.
Sean
And Judge, as the officer's coming out, I would just want to move into evidence defense exhibit 236. That was the printout of text strings between the last witness that was testified to.
Any objection?
None.
Received. 236. And you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God. Please be seated.
Officer, could you please state your name for the record and spell it?
Officer Sean Giovannoni, G-I-O-V-A-N-N-O-N-I.
And how are you currently employed?
With City of Kenosha Police Department, 3rd Shift Patrol.
And were you employed in such a capacity on May 19th of 2020 at roughly 10:43 p.m.?
Yes, I was.
And on that day, were you also working 3rd Shift Patrol?
I was.
And would 10:43 p.m. be shortly after you got on duty that night?
Yes.
And as part of your duties, do you have any sort of special training that leads you to have a slightly different role at crime scenes than potentially other patrol officers?
Yes, I do.
And what is that title?
Evidence technician.
And back on May 19th of 2020, were you also an evidence technician?
Yes, I was.
And when you got to work that day, were you dispatched to a search warrant occurring at 6813 West Highland Road in Mequon?
Yes.
And did you respond to that location to perform evidence technician duties?
Yes, I did.
What can you tell us generally about the residence itself after you had arrived?
About the layout or anything?
Yes.
Is that what you're asking?
Yep, what do you remember?
It was a 2-story house, a single-family home with a basement. I remember when I walked in that the walls, as I described, looked like it was on renovation because all studs were exposed, and there was debris and clutter throughout the lower level.
I'm going to show you some pictures from State's Exhibit 1, starting with photo number 265. If you want to direct your attention to the screen.
She was just talking to her mic the whole time. Because the 8th grader that's running the audio here in the courtroom is having a hard time keeping up with what she's doing. Are we boring you, sir? Apologies. Somebody is typing up a storm. They're like angry typing. That keyboard might need to be replaced when they're done typing. Are they generating the document right now? Internships are important.
No, the TV flicked on and then it...
The bailiff back there could not care less if the TV comes on or doesn't come on. He gets paid the same either way. It's a real-world keyboard warrior. You're right, Johnny Law.
Thank you, Detective. Now, obviously, you were there in the evening hours. Is that accurate?
That is correct.
But is this, in general, what it looked like when you were there as an evidence tech on the night of the 19th?
There's a kitchen sink.
And
Literally
what area are we
everything
looking
and
at
the
this
kitchen
residence,
sink
if you know?
is right there.
This looks like the back porch area when you first walk into the residence.
I'm going to show you picture number 266. What are we looking at here?
This is the lower level of the house.
Oh my goodness.
And
dartboard on the wall.
does this picture depict some of the exposed studs and under renovation feel of the home?
Yes, it does.
And does this appear to be an accurate representation of what it looked like the night you were there to help in the search?
Yes.
Show you number 267. What is this vantage point?
Different area of the lower level.
Towards the
like a
right side of
server
this
rack in there.
exhibit, is there a couch and a TV?
Yes, there is.
And is there also an ottoman there?
Correct.
Would you characterize that as the living room?
Yeah.
Right.
There's no living
Showing
going
you
on in that room, though.
268. What is the general look of this picture?
That's where you come in from the back door off the porch.
And was
You
this the
just,
general
like,
condition of it when you assisted in the
Have
search
to
on the
high
night of the
jump
19th?
over this and get in.
Picture number 270. What is this a picture of?
The area where the couch is on the lower level.
No leg
And
lamp.
in your role as an evidence technician, were there other officers and detectives assisting in the search?
Yes, there was.
And if they would locate something that they thought had evidentiary value, was it then your job to photograph and collect it?
Yes, it is.
And were you also participating in the search at the same time?
Yes.
I'm going to show you. I'm going to ask, in this picture, you had talked about a ottoman. Would you mind getting out of your seat and just pointing out where that ottoman is in this picture?
Sure.
And you can grab a seat. And was there anything of evidentiary value that was discovered in that ottoman, if you know?
Yes, there is a, there is a bag with a large sum of money in it.
I'm going to show you what's been
ZA's
marked as photograph number 296. What is this a picture of?
The bag with the large amount of currency.
Money.
And when you say a large amount of currency, was one of the jobs that you assisted in counting that currency?
Yes, it was.
And what, if you recall, was the total amount of money inside that bag?
$46,000.
About $47,700 some odd dollars. I don't remember the exact amount, but almost $48,000.
And what kind of bag was it in, if you recall?
Cha-ching.
It was in a bank bag, I believe.
Were there other items of evidentiary value that were located by other officers on the main floor of the residence?
Yes.
And what were some of those items?
There was some drug paraphernalia and I believe a camera.
When you say drug paraphernalia, what do you mean?
Large amount of marijuana, a couple of different bags. There was a container with a grinder in it, marijuana grinder with appeared to be marijuana seeds in it.
I'm showing you it's been marked as number 295. Can you tell me what that is?
That's the
I'm
container.
going to object to the relevancy of this evidence.
So, Judge,
What's wrong, bud?
The door was open to this in the Christine Remsburg testimony. We previously argued about this, and this is our recitation of that evidence that we previewed for the court.
Objections overruled.
This is ZA's house.
What is this? What is inside this container, if you know?
Judge, sorry, I am going to object again and make a record that their questioning on the cross-examination of Ms. Remsburg had to deal with a grow operation in the residence with plants. So I don't believe that any of this evidence is relevant or really.
Overruled.
Officer, what is this?
This is the container that had the metal marijuana grinder on it and apparent marijuana seeds.
And you indicated marijuana seeds. Is that what we're looking at
You
here?
said apparent marijuana seeds.
I couldn't hear him. I apologize.
You don't have to apologize. It's,
How do you know when they're
spend more money on
kid
the system.
marijuana seeds if they're all parents?
And there's a couple of, I think, 5 different what looks like to be canisters in there with or jars of some kind. Is that accurate?
Correct.
And is there some sort of handwriting on each of those jars?
There's different names on each jar.
It says Purple Kush. I don't know. What's that mean?
I'm going to show you. Picture number 307.
We're in Wisconsin, right?
Can you tell me what this is?
That's one of the bags that had marijuana in it.
And was that also located on that lower level?
Yes, it was.
No seeds in that
I'm
bag.
going to show you picture number 308. Can you tell me what that is?
Looks to be a mushroom.
I'm going to object as far as relevance to mushrooms.
It's just mold.
Same thing, Judge. If you have a marijuana grow and you are also manufacturing and putting together mushrooms, again, Ms. Christine Remsburg's ability identified on cross to be able to tell whether the defendant was perhaps hiding anything from her or concealing some of his activity is directly relevant.
To Judge, to that point, the state didn't ask her about anything dealing with a mushroom grower operation, and one doesn't mean the other exists.
It's exactly the same concept, Judge.
The objections overruled.
Oh, they're letting in all these. This is not good for him.
You can answer if he hasn't already.
I'm sorry, what was this object that's in this picture depicted?
Appears to be a mushroom.
Psychedelic mushroom.
Specifically yourself responsible for helping to search the stairway leading up to the second floor of the residence and the second floor itself?
Yes, I was.
And on that stairway, do you recall, on the second floor, do you recall finding a bedroom that you were able to attribute to someone?
Yes, I did.
And how were you able to attribute that bedroom to a specific person?
I found a Wisconsin driver's license in there.
Was there anything else located in that bedroom that you thought had evidentiary value?
Yes.
And what were those items, the best you can recall?
There was a laptop computer, a couple hard drives for a computer, and I think 3 computer towers.
I'm going to show you what's been marked as picture number 303. Is that some of the things that you found in that bedroom?
That is correct.
And there's a box that's sitting on top of the yellow legal pad. Can you tell us what was in that box?
Mini GPS system.
And you had indicated that you had recovered a laptop, is that correct?
Correct.
And you what's previously been marked as State's Exhibit 114. Based on the packaging alone, can you indicate to us what this is?
No, we
and
need
if
the
this
mic.
was a laptop that you recovered that night?
Yes.
And how do you know that that's a laptop you recovered in the bedroom of Mr. Anderson?
Well, feels like a laptop in here without looking.
Are there information on the tags itself that are put on the front of things that
You might regret that, Matthew.
illustrate what is contained inside of an evidence package?
Yes.
And what does this one say?
MSI laptop with charger.
And is that something you recovered from Mr. Anderson's room that night?
That is correct.
Let me just grab that from you.
Objection?
No objection.
Received.
And I'm directing your attention back down to the first floor of the residence. I'm going to show you picture number 297. Tell me if you recognize what is in this picture.
Yes, those look like seats out of a vehicle.
And were those located in the residence on the night you helped search?
They were.
He just like threw the seats in the house, just chucked them in there. Of course, he did that with just about everything else he owned too. They are sped up still, 125%, 1.25. That's awesome, Matthew. If you guys missed, Matthew, scroll up a little bit. He's giving away Matthew Harris Law drink koozies, but you have to go over to Discord to get it. So if you need to help get into Discord, go ahead and type !Discord in chat here. It will respond with the link, and that will get you in there. You'll have to follow a couple steps to get started, but that'll get you on the way to be able to request a free can koozie, which just makes every drink cooler. I'm not sure. I missed what we're waiting for. Yes, we're getting into the stocking room. Had a tracker in there. Car tracker.
No further questions. Thank you.
Cross-examine.
Yes, if I can just have a brief moment, I have to confer with Detective Correa.
Defense has to confer with Detective Correa prior to questioning this officer. Somebody's tired. We caught you. A little sleepy. Are you out, Thomas? We're trying to get caught up as fast as we can. We've got a little ways more to go. I know today we've got the girlfriend, Sadie, there in back. I think she's going to be testifying today, right? MCAT, thank you for gifting membership. Looks like right on Josephine received that. Congratulations and thank you, respectively. Well, Missy, man, have a good trip. We'll see you next week, and then we'll have the podcast again. Not this Friday, but next Friday, because Weather Watch is going to be out of town.
So you were responsible for collecting evidence from Mr. Anderson's property?
Correct.
And so this grouping of photos here, you collected these papers, correct?
Yes.
Okay. And do you remember how you logged them all together?
Not particularly, no.
Okay. Can I hand you what's been marked as Defense Exhibit 241? Before you open it, if you could just read the description on that exhibit.
It says court paperwork, other miscellaneous paper.
Okay, and if you'd be so kind to open it.
There's the ASMR we were missing. Rachel, welcome. Thanks for subscribing. You didn't know you were admitting to being an addict, but you did, and we love you for it. Welcome. Hope you love it here. Now you can't leave.
Okay. And could you briefly just go through those papers and tell me if you find a receipt?
I'm sorry, did you answer him, counsel?
Are there any receipts in there?
No, not like a shopping receipt.
Judge, may I go to the witness?
It's missing. Evidence has gone missing. I'd like to did you give him the wrong stuff? Keep looking. Keep looking. It's in there somewhere.
In the meantime, can we take a look at this receipt? This exhibit wasn't shown to us, so could we inspect that?
Let's do it in a public place so nobody steal anything. This exhibit was not shown to the attorneys. What is going on? How did they have this evidence that they didn't know about? It's clearly marked with evidence tape. I don't know who screwed this up, but it's crazy. Some settling maker and shipping. Yeah, I think the receipt's all the way at the bottom. This is all in front of the jury, and they're like, we have no idea what this evidence is. Do you mind if we take a quick peek? I don't know how did defense know about this, but prosecution didn't when it's state's evidence. I mean, it's crime scene evidence. Receipts are printed on cheap paper. It just evaporated, apparently. Defense lawyers walking around the courtroom looking on the floor as if the receipt might have fallen out somewhere.
So there was no receipt in that exhibit for tax returns, correct?
Not that I saw, no.
Tax return receipt.
So in this picture, and if you need to take it off the Elmo to look
There's
at
a
it
receipt. I'm
closer
covering
up,
it a little bit.
Do you see a receipt for an item?
Objection. How do we know this is the same as the exhibit we just saw?
Well,
or are you
the exhibit did not. I asked him if the exhibit had any receipts, and he said no.
Right. So will this picture be relevant to you? Objection. Relevance. Why would this picture
have a discussion of this outside of the presence of the jury.
What is that photograph? What is that depict as a general? The entirety of it.
Sure. As the officer already testified to, that these are items that he got together from Mr. Anderson's home. Those were logged as evidence as miscellaneous paperwork, which was supposed to be item 19. These papers are not in Exhibit 19 or item 19. So now I only have the picture to rely off of.
Now, what is your objection?
My objection is that we just opened this and it doesn't have those items. So why this picture purports to be the miscellaneous paperwork? That paperwork is not in this item. So they're not one and the same.
Well,
I'm not asking about that exhibit anymore.
You can cover it on your redirect. What does this photograph depict again, Austin?
It seemed like paperwork that was photographed at the residence.
And where did the paperwork then go?
So all the paperwork that I collected, I plugged in evidence. There might have been some paperwork that wasn't actually collected as evidence, but just photographed. So.
Yeah, this is why I asked for a sidebar, because I had viewed those. Yeah.
Continue.
Thank you.
I couldn't hear the court. I apologize.
I said you could continue.
Thank you.
And I can hand this to you so you can more clearly see it, perhaps. But was there a receipt? Do you want me to hand it to you?
Yes, please.
I wonder who did the
Do you
taxes
see
for
any
it.
sort of receipts in that photograph?
With
You don't see a...
Oh, I'm sorry, in the photograph, yes.
Okay. And could you point those out, and perhaps if you could put this back on here so you can show the jury? If you could just get the pointer that the judge has and go up to the TV.
Sure.
Or you can just point it out on this.
Thank you.
You don't have to point it out on the TV.
The
You
receipts
have a device
that
right
you
in
have,
front of him that will show the pointer as well. Missing evidence is good for the
Okay,
defense,
that's a Walmart
always.
receipt. Okay, do you see another receipt that's in the upper right-hand corner of the photograph?
Yes, sir.
Okay, and did you log that receipt that we see on the top right photograph separately?
So this is a table in our evidence room. So
Table in where?
Officer.
Oh, sorry.
It's in the evidence room, he said.
This is a table in our evidence room, and when I log evidence, I put paper down so there's no cross-examination. So if this is in the evidence room, I did log it.
Okay.
Counsel, could we just have a moment of your time? Just have a moment of your time.
They might stipulate something here. We're going to see what happens. Oh, this is funny. Taxes were done in Menominee Falls per defense opening. So I wonder if the taxes covered the income from the marijuana grow. The reason I ask is because of the federal laws against marijuana that still are in place, federally, that affects every state. So even if it's legal on a state level, federally, where money's involved, businesses are hesitant to be involved in that. That's why a lot of the marijuana grow operations are cash-based, because it's so hard to get a bank that will accept the deposits, because the bank feels that if the feds decide to step in and they say, hey, you're doing this business, this illicit business with this company, we want to shut you down because of that. So having a tax company be able to do your taxes for you, it just makes you curious. Now this is a good trial. It's got everything in it, except the body. No body. That's the only thing that would make it better. Let's see what they stipulated to. I think they did here.
Judge, may I continue?
Go ahead.
Thank you.
Nope.
So the receipt on the upper hand corner, you can come back and sit down, officer. Thank you. Obviously, you'd agree that the picture up on the Elmo looks a little blurry.
Yes.
So it's hard to make out what exactly that receipt says or the paper underneath the receipt says.
That is correct.
And if you wanted to look at the exhibit itself, is it any clearer?
Judge, again, I'm
And
going
this
to object. I apologize, counsel. It is. I don't believe that counsel is actually purporting that the officer actually processed the evidence in the picture that she is showing this witness.
No, she is.
Well, you're using the word processed.
That he would be the custodian or the person who in some way dealt with this evidence. So I believe this is not a witness who is specifically familiar with this evidence.
I think his prior testimony was that he did log this evidence.
Well, you're using terms from the legal system like process and log. Have you ever seen this before? Right here.
Thank you.
He's got a magnifying glass.
Yeah, I don't know.
Sweet.
Enter. So because it was a long day, I did have assistance with logging the evidence. I don't remember every document that I put in there, but like I said, if it's on this table, we logged it. I did have other officers helping me just because of the currency. We have to have multiple officers as policy to verify a count. So. Okay.
And this has already been this has already been accepted into evidence. So when you looked at the document, this receipt and paperwork that was on the upper right-hand side, when you had looked at it, were you able to make out what the writing says?
On that paper, no.
Even when you looked at it closer up?
I couldn't.
Okay. The state had shown you an exhibit that was a photo taken from a desk in Mr. Anderson's home. On those were some items. Do you remember?
Yes, the driver's license.
Yeah.
Yes.
And why did it go away? Okay, it just abruptly ended. This one started 2 hours ago. It was on the stand here. Just 1 second. Let's see where we're at. That's the new one. That video just ended. Uh-oh. Let's see what's happening. I wanted to see where that was going. I was actually loading up my Peter Griffin sound effects because I thought a couple would be useful right there. And you can see I've got Peter Griffin YouTube playing here in the background. But apparently we can't do that anymore. That video just disappeared. It was 1 day ago, just double checking, making sure we got everything right. Oh, it's because the day just ended. That's why. Okay, I've got it here. We've got Pete Griffin on the stand. Let's see if this is any better here. Got too many devices, and I choose to use the iPad that's not on my desk to run everything. We need some music, like some theme music. Yeah, the video is over and they cut it, is what happened. So we've got to find the rest of it. The stream did end for the day, which means, let's see, it's 6 o'clock here. Okay, maybe we need to end for a little bit too. Let's do this. We'll, I think if we end for the day, Danny wants me to sing. That's not going to happen today. Not tonight, Danny. Maybe another day. I'm not saying there's like zero chance of me singing. It's just not going to be today. So that's where that one is. Let's see. So the video's over. That means they're... What time is it? Okay, so we've got a couple hours. I think we're going to start a little bit early tomorrow. We're going to pull it up. I might summarize a little bit of what we missed from the end of this officer up until tomorrow. It just depends whether if there's something juicy, which I think there will be. We're going to want to watch that, and so we'll bring that in for sure, and we'll watch it tomorrow, and then we'll be back up to speed by the time they start trial at 10 o'clock my time. So that'll give us enough time to get everything watched and caught up, and then we'll be tomorrow on time when they start court. Is that fair? Any complaints there? We'll get the juicy stuff. We're not going to miss that. What is that? A little violin? Oh, yeah. Karaoke night tomorrow, says Danny. No. Not here. I do sing a little bit. Thanks. Throw me under the bus. We should be able to catch up. Yeah, we'll do it tomorrow. So that means I'll work all night long. You guys take a break. I'll work all night watching this, getting all the timestamps right, getting the videos ready. So we're going to have a video ready for the morning for us to talk about what we missed here. If there's anything juicy, I'm going to include it. If it's like really good back and forth, if the claws come out, if there's blood, we're going to show that. Carol, we normally start at 9 a.m. I'll probably try to start half an hour early. That would put it at 8:30. I know there's a couple of you on the West Coast that's pretty miserable for you. I do apologize, but it's your fault for living on the wrong side of the country. So, I live on the East Coast, and the sun rises over here. I can't sit around much longer after 8 or 9 to get started. Let's see. So no more today. I can do it today. It just takes some work to put it together. Clearly, the video stream is not up right now because they just ended it, so I'm waiting for it to like repost again, and then we'll pick up where we left off. So it'll just take some time. Bullwinkles and Sprinkle says, "Hey, I've been lurking. Thanks for coming out of the shadows. Appreciate you being here. You do us proud," says Leader Writer. Kickstar says, "Good time, Seattle tomorrow." Matthew Harris, thank you. The koozies are going to everybody. I think that's awesome. 11 p.m. UK time. Whoop whoop. I sing tenor, of course. It's more of soprano, Adam. As those higher registers are really where I'm comfortable in my range. Tomorrow sounds good. Have a good night, Tag, as well. What time again? So I'm going to say 8:30. 8:30 sounds good. Have a great night. We aren't catching up. Oh, I wanted to, but the feed got cut, and it will be up again. But that's good. So 8:30 Eastern time. I normally start at 9 o'clock Eastern time, so it's a half an hour earlier. We might, if we skip roll call tomorrow and just cut straight to the good stuff, we should be able to catch up and watch everything. Yeah, Lawn Crime ended a couple minutes ago. I think they just like shut off the feed and it basically kicked all of us off. The East slice of lasagna tastes better. This is true. They did adjourn for the day. We will catch up. We want to hear Sadie. I don't think we can skip Sadie's. What's up? Oh, I need to go because dinner's ready. Mrs. R.A. just came in and said dinner's ready, which means we need to play this music. They don't start till 10 Eastern time. That'll give us enough time to get today's what we missed. And then when they start tomorrow at 10 Eastern time, we'll be live. And then we won't have a million questions saying, is this live? But that's what we're going to do. I do want to thank everybody who watched today, who came out of the shadows and said hello, who subscribed to the channel, who just hung out, who lurked. All those people who became members today or were gifted a membership today, thank you for joining. I appreciate that. For all those who did gift memberships or give a super chat, thank you so much for supporting the channel. It makes this all be able to be, what it is. And I thank you very much, and my family does as well. That being said, tonight when you go home, please hug the people you love. Smile at someone who needs it, strangers. Make their day just a little bit better. And please stay safe till tomorrow when you go live at 8:30 in the morning. Miss Larry's going to kill me. I'm going to have to cut her exercise short. But that's what we're going to do. 8:30 tomorrow. We're gonna get started. We're going to get all the way caught up. I like the sparring between the two counsels. This is such a good trial for that. The actual facts of the case are not as important to me as the back and forth between the two sides. This is adversarial, the system better than I've ever seen it. So we have time for a lot of it then. Yes, we will. See if there are any other comments here. Saved by the dinner bell. If you need more legal content, please check out Matthew Harris Law's channel right here. Anytime you need it when I'm live, you can type !Matthew in chat and it will pop up. I think that's all I've got time for. I'm running out of music. You guys have a great day. Thanks for being here. We'll catch you on the flip side. See ya.
Are we going to address subject matter jurisdiction?